The model where? The passing of committees is under challenge.
Not listed.
Till today. What kind of? The matter is specifically directed to list today, man. That has not listed a hearing. Whenever it will be heard, continue. But the lower court date is fixed on 19th. That's why. He takes. Tomorrow, no, not.
May I mention? Your Lordship, it's a CRLA matter, and I am a junior engineer, and I have been terminated from a job out of conviction for 1 year. And I had already mentioned this case.
Appeal.
Yes, criminal appeal. Your Lordship, maybe may listed next week. It's urgent. Much obliged.
Your Lordships, I'm in VC. May I mention, Your Lordship? Your Lordships, I'm in VC. Lordships, CRLMC number 3483 of 2022. Lordships, in this matter, a stay is operating since last 3 years, Your Lordships. And the court has specifically asked this matter to be listed, Your Lordship, last year. Opposite side, Your Lordships.
Yeah, opposite side.
I've informed the opposite side, Your Lordships. And they're willing to, Your Lordships.
I am appearing on behalf of Mr. Soumyaranjan Mahanti, for which my learned senior is mentioning, my lord.
Yes.
Lordship, the date may be fixed, Your Lordship, so that.
Stay is operating since last 3 years.
Yes, Your Lordship.
Yes, my lords. We are ready with the hearing, my lords. We have a short written note to give.
Give the memo, Give the memo.
My lord.
Because the Lordship, the trial court is not willing to proceed with the matter. Unnecessarily, the matter is lingering.
Okay, give the memo. I'll adjust that, please.
I'm grateful.
My lord, I am in VC, my lord. My lord.
Yes.
Yes, my lord. My lord, there is a urgency in my matter, CRLMC 1475 of 25. That, my lord, I am here for asking, praying for release of interim vessel, interim release of my ship, my lord, which is lying in dock since last 1.5 years, my lord. And there is a complete order in favor of us by the learned additional session judge Kujang, my lord.
Is there any arrest order?
No, my lord. No, my lord.
Pending.
No, nothing is pending, my lord. There.
Give the memo.
Yes, my lord.
Lordship, may I mention?
Yes, my lord. 457.
CRLM MC number 4264 of 2024, Lordship. Lordship, in this matter, this is the case where the FIR was registered out of the matrimonial dispute by the husband. And now the 13B has been filed before the court of district family court in Ludhiana. So that case is for quashing of the FIR filed with the Sambalpur court, Lordship. The Lordship, this matter may be listed either tomorrow or the next week.
Give the memo, we get feedback. Okay.
Yes, Lordship.
Do we have anybody here?
Yes, Lordship. One junior associate there.
Give all memos. Give all.
Obliged, Lordship. Deeply obliged.
Yes. Page wise.
Item number 1 to 7.
Lordship, item number 4, praying for an adjournment.
Item number 2, my lords.
4.
I pray next week.
4 on the request of counsel. Yes.
Item 6, my lord. My lord,
Item number
compromise matter, I pray kindly taken up tomorrow, my lord.
What are the offences?
My lord, 506 and other available offences.
Why tomorrow?
My lord, inconvenient of the party, so I pray before lords.
The inconvenient of court is not more important.
My lord, I'm sorry, my lord.
The accused convenience is very important.
No, my lord, I'm not on that, my lord. I'm sorry, my lord. Kindly taken up.
I'll take it up according to.
My lord,
They
tomorrow.
can't dictate the court. Accused can't dictate the court. I'll come tomorrow, take up my matter. Either you come today or I'll impose cost and dismiss. Don't do that. It's not on the basis of accused convenience. If you have problem, you tell me. I can accommodate you.
My lord, the opposite party advocate.
Don't make that kind of mentioning. Accused has an inconvenience, so that take up.
My lord, sorry, my lord. Kindly taken up tomorrow. My lord, affidavit already filed, my lord.
Maybe, but if you have any problem of your personal problem, you tell as a lawyer.
My lord.
Don't even say that the accused has a inconvenience, so they'll come tomorrow, take up the matter. We are not here to accommodate the accused.
My lord.
420 accused and he needs, according to his convenience, he'll come.
My lord,
Fix
he's,
it whenever.
my lord,
Yes, next.
they're on road.
No, next.
Item 7,
Yes,
taken up someday a week after.
week after.
My lords, I'm on VC, item number 2, my lords.
Entry vote.
Item number 2, my lords, I'm on
Same. Okay. Sir, appearance.
item number 2, my lords, I pray that it may be taken up next week, my lords.
Why, what is the problem?
My lords, personal difficulty of the
Not
conducting,
next week while I recommend it.
my lords, as your lordship please.
Yes.
Item 8 to 16.
Pardon me, it's item number 12, my lords. Lord, kindly order it after, my lord.
12.
Item 12,
What do you want?
after 1 week, my lord.
After lunch?
After 1 week, my lords.
After 1 week.
Bye.
On request. Huh?
Item 11. Next week.
On request. Not next week if you go. Yes.
Item 17 to 30.
Which item? 1-5.
Item 17 to 30.
Press matters, anything asking opinion, put it after July, huh? Yes.
31 to 35. 36 to 40. 44 to 49.
48 minutes, I pay an adjournment minute, note my client has taken the file and not returned.
On the request of the council.
Sorted.
48. Short date, huh? This side of the vacation. Is over, yes. Now, the fresh matters, I'm trying to list, if for the fresh matters, nobody is interested, it will go in the July. That's the, yes.
50 to 56.
Item 50, my lord.
50?
50.
Yes.
Today is the mediation date is fixed for today, 1 p.m.
Then next week,
And-
mediation process is going on. Please the matter up to 1 week. Is
Item
there a chance of?
Yes, lord. This is the third sitting of mediation.
Then there is a chance, short date, yeah. Next week or the
Item one of the continue.
entry one.
Item number 56. Doctor, I've had some personal difficulties.
Okay, personal difficulty. Yes. 56.
56.
I am for the opposite party.
Personal,
After vacation, my lord,
Entry model.
yes, entry one.
after vacation.
Not after vacation. You are the opposite party.
My lord,
The interim order is
they
there.
are taking interim order.
So you want after it, let it come after vacation.
No, next week. Next week.
My lord, in
Let it be this side of the
Yes.
vacation. This side of the. Yes.
57 to 62.
Item 57, Millard, I am for the opposite party, why? Millard, for the other side, since my senior is appearing, and there is a chance if I take instruction about any kind of settlement, because of matrimonial case, husband is staying in USA, the Google high official is not coming, but it since already they are not staying together, and some series of,
I'll send it to mediation.
I'll take instruction and I'll go to
No, but
meet my senior, we'll both will discuss.
Let's record that. What he has told me is that he will give me a proposal. And first
No,
we'll
may
try
not
and
record you, sir.
then all can go.
I'll go to you.
No, the best part is I will send it to mediation through video conference, let him appear and I fix it.
All fair.
That's,
all.
I'll tell you, it's neither on you nor on him. I'll send it to mediation, 57. Send your junior, sir.
Interim order to continue.
Interim order will continue. Send your junior.
Right.
I'll send it to High Court Mediation Center.
Yes.
Allow you to participate through video conference.
Yes.
Video conference, both you
From
are.
USA, he will come.
Grateful.
That would be a better idea.
My lord.
Now, since my senior has appeared, because Supreme Court, it has failed. Now, there is a hope if my senior will be there, then it can be.
All right.
I'll refer it, 57.
Fine.
Please come.
63 to 68. Item number 53. I'm for the open letter.
Who is it?
63.
On the request. You don't have any opinion?
No, ma'am.
On the request.
Ito ko ilan 63.
68. Yes, sir. What do you want? Why? Come to the front.
Previous council concern first time pen listing is the prepare kuri.
Sorry.
But consent brief ta my lord. The previous council consent ne ki first time pe appear korchu to. First time pen listing is.
Yes.
69 to 76. 77 to 84. 81, my.
81 years.
Next week, ma'am.
Next week.
My lord, item,
Urgent. This press matter, it will go to the,
my lord, item 80, my lord. Kindly be taken up next week, my lord. The compromise
next week.
of like lords.
Settle, the dispute settle?
Yes, yes, my lord.
What are the offences?
File has not come.
What are the offences, you tell me?
As per my instruction, my lord, 307 and other offences are there, my lord.
You don't have the
It
file.
cannot be
No,
settled,
ma'am.
my lordship. I have obtained the case right away.
Mm-hmm. 307.
Yes.
Urgent, down.
Of like lords.
8, yeah? 80.
Of like lords.
85 and 86.
Over me.
85 and 85.
You are talking about 80?
Which
If it's a covered case, who is appearing for?
not came.
You give that judgment and I'll take it up.
Yes, I have
1,
argued
2,
that one.
3 matter we can dispose it up.
I have argued that one.
Judgment.
Only last.
Call him at 2 o'clock and take it. If it is covered, if he says that it is covered, I'll.
No, no, I have same issue, one are already put their explanation.
Call Mr. Das, who can
Fine.
Maybe-
mention your lordship, item 52 your lordship.
50?
52.
Yes.
And for the informant, there is a health problem of the council of the petitioner. Refer next week, your lordship.
Who is the
On behalf of Mahapatra.
52? Adjourn on the request, joint request. Joint request.
Every corner, case matter,
May I be allowed to make a mention, your lordship? It's a quashing of prior application. It was posted to be listed on 10th. It has not come up on the list. Let me.
Give the memo, man. Give that request. Give that memo. Yes. Start.
Item 1.
हाँ, OPID में.
Is there actually?
Sorry.
Yes.
Here, Lordship, is a case where the case arising out of a complaint case subsequently converted to GR, Lordship, and the allegation, Lordship, may kindly turn to page 18.
What are you seeking here?
Seeking the challenging order of cognizance. In fact, the case is that, Lordship, in a complaint case, some persons have complained that myself and other persons of the company, they have defrauded the persons. Accordingly, 4,60,000 was the amount involved in that complaint. In view of that, subsequently, one of the prime accused, who is no more as in debt, he has committed suicide. He has enough to avail a bail of the Honorable Court by the order of the Honorable Court. He has deposited the entire complaint amount or the disputed amount before the learned court below, and he availed the bail. That amount is deposited as in debt before the learned trial court. Now the question is that this person has been appointed as the accountant. I have annexed the document, and thereafter this person and the main director and his wife, these 3 persons were charge sheeted under this OPID and the charge sheet from non-settlement set. And now the case is that case is pending. It's not a trial is not yet committed. Charge sheet is submitted, Lordship. The question is that as because it's a complaint case and the amount disputed amount has already been deposited in the learned court below, there remains nothing to be adjudicated. But I pray. I have made them all the complainant groups, about 8 persons. I have made them opposite parties. If they will be before Lordship, then matter can be settled. Because the amount which they are claiming is already been paid, deposited.
No, these are the 8%, those 9%, those
8%.
came forward.
They will
9% came forward.
came forward.
We don't know how many people you have seen.
No, that is the charge sheet. I have managed that charge sheet says that it is
They don't know.
2,60,000.
How many people? A total?
That record will say,
Huh?
record I have not similar kind down to page 53.
53.
NBW has been issued since 2022 without surrendering approach this honorable court.
No, in fact, that document says in this way, but today, yesterday I had taken the instruction that this person He has already appeared, is appearing in the court, but the other co-equal, the wife of the main director, because he is absconding, enactment has not been executed till date, for that reason the case is pending. Case. We have, that part is no dispute.
So what do you?
I pray that as because the dispute amount already been deposited, nothing remains to be executed, so far the amount is concerned. So I pray Lordship kindly, no, office, that is so far the main director of the sub concerned.
Have I issued notice?
No, it's a for the.
I'll simply issue notice, let us see. I'll issue notice.
Possibly, yes, possibly. I think it's, if admittedly their money has been deposited.
Yes,
That is what the case.
I'll issue notice. Issue notice, don't go, accept notice for opposite party number 1. Process fee to be filed within by tomorrow for effecting service on 2 to 9. Yes. Next.
By end of 6.
Yes. Do it. Yes. Next.
Item 3.
Three.
Item 5.
Please, your lordship. Lordship, petitioner before your lordships. He is a lessee, my lords, of a stone quarry, my lords, from the Jagannath Temple
Got the
administration.
I mean, sir. What instruction you got?
And it stated that the open filed by it's he examined that person. Person stated that I have no knowledge that there is a.
No, what is instruction?
The lawsuit says some additional document may not be notified. That stating that one is temple administration.
Lords, can I explain
Yes,
here?
let me understand. Yes.
What has happened is, I am the lessee of a mine, my lords, which was auctioned in the year 2017, my lords. I was the highest bidder and it was knocked off in my favor. Now, possession of the mine has not yet been given to me. Because, my lords, compliances are required to obtain, my lords, permissions and etc. The lease deed was executed with them in the year 2023, my lords. And thereafter also possession was not handed over. After the lease deed was executed, it was found, my lords, that the boundaries were erroneously given. And the area which was there was small in size compared to the original boundary. So, my lords, a re-verification of boundaries was done by the mining consultant of the temple, my lords. And they redrew the boundaries, and it was found that areas which belonged to me, but which was not within my allotted area because of the illegal drawing of boundaries, my lords, illegal mining had happened. A show cause was issued to me, my lords, as to why I should not be blacklisted. I replied to that show cause saying that I am not responsible. Thereafter,
Land was allotted, no demarcation.
Yes,
nothing, you had no
yes,
idea.
yes.
That's what you think.
That's what I said. Then, my lords, the Jagannath Temple administration imposed on me a penalty, my lords. I have challenged that penalty in this court, my lords, in a writ petition. That order I have given today. There, my lords, the court has observed that any action taken pursuant to the impugned order will be subject to final decision of the writ petition. Now, they have not filed a counter. Yes. Now, the temple administration filed the FIR, my lords, at page 11, my lords. That is at page 13, my lords, the formal FIR, plain paper FIR. There they alleged, my lords, that the leaseholder had extracted illegal building stones. And they further alleged that this leaseholder had not made deposits, my lords. Now, both of these things, my lords, I said, are erroneous. Your lordships granted anticipatory bail to me. Now, after that, my lords, the police people, what they have done is frozen my account. Therefore, I have come up before your lordship in this 482 application. Yes. That it should not be frozen in view of the fact, my lords, that possession had not been handed
You
over
are
to
not
me.
challenging the FIR.
I am challenging the FIR also, my lords. Why I am challenging the FIR? Your lordship may kindly look at page 13.
Yes.
Se Kauchanti, in inviting reference to the subject cited above, I so and so, at present Deputy Administrator Revenue SJTA Puri, inform you that a lease agreement was executed with Ajay Agarwal with respect to operation of Dhania New Building Stone Quarry Uttaratar of DA, Kaipadar on 5-10-23. On the basis of being the highest bidder in the auction conducted on 2-8-18. Though the leaseholder got environmental clearance in respect of the quarry on 3-3-22, he suppressed the matter, handed over the EC to SJTA office only on 14-10-22 after a gap of 7 months. Because I could only hand over when I get that clearance. Then they say he also did not deposit royalty and other dues amounting to 58,70,538 with SJTA as noticed to him by letter dated 11/11/22. Your lordship got it. Now this is palpably wrong.
The read court will decide.
No, I have already deposited the royalty. That I have given in the additional documents filed on 25/11/2024, my lords. Your lordship may see there are some documents with a memo dated 25/11.
I got it. Which letter you are talking about?
I am talking of the second letter, my lord. Letter dated 28/6/23.
Deposit of royalty.
Aye. Enclosure tadher tole lekha haichi. Original DD worth 58,70,538.
The investigation is going on.
It's going on.
What about the release? What are you talking about the release? Instruction. Now concentrate on the release of the investigation.
Now this is palpably wrong, my lords. The second thing they say in the FIR is that it is reported by the mining consultant Chandrabhanu Das that there is extraction of 1,47,873 cubic meters of building stone from the quarry till 31/3/23 up to the year 22-23. Accordingly, I was noticed to deposit 2,90,24,702 by office letter dated 8/11/23, which I have not deposited, although I received the letter and I am said to be dishonestly misappropriated. Now I have given the copy of the writ petition, my lord, wherein your lordship has protected me. Now, my lords, what they say in the FIR that Chandrabhanu Das's report shows that I have committed that illegal mining. I contend that that is not so. And therefore, I have filed Annexure 2, my lords, at page 17.
Yes.
Has your lordship got? Chandrabhanu Das writes that the volume of excavation depicted in my earlier report includes the total excavation of stones from the quarry during the period of survey of mining plan, that is in 19 till May 2023. As revealed from your above referred letter, lease has been executed with effect from 5/10/23. As per Rule 43(2) of the OMMCR 23, quarry lease is valid from date of registration of lease deed. As in this context, lease was not executed till May 2023, present lessee would not be responsible. This is his opinion. To that, my lords, when I filed this document, your lordship raised a query because the state took an objection. Now what? Yes. Now the state has got some query made to him by the IO, and he says that this was not known to me. Lords, even if it was not known to him, lords.
What about release of the account?
Release of the account, my lord, first instance, my lord, senior stated that after keeping the 2 crores or somewhat, the rest may be released.
I'll do one thing. I'll pass that order and direct the IO to take into consideration the additional documents and everything. And
he has taken into consideration thereafter examining that.
No, this is no way of doing it. And he writes a letter and see, I don't agree with it. Release 2 crores, na?
My whole problem is, my lords, my accounts don't contain that amount.
Retain 2 crores and
They don't contain that much of amount, my lords. All those accounts together in total don't contain 2 crore and 91 lakhs. But in view of the High Court's order, my lords, that it is subject to the results of the writ petition, lords, why should they insist on that?
but how will they recover?
If, my lords, it is found that I am due, it will be recovered from me, my lords. Let them
What
give
is
me
what is the amount? What is the amount?
2 crores, 9.
Recovery?
2 crores 91 lakhs.
Now, where are the accounts? Do you have a freezing of account? How many accounts are freezed? Account number 1.
About 4 accounts have been
4 accounts.
seized.
You say money is not lying there?
No,
All the 4
no,
accounts.
that much of amount doesn't lie there.
Do you have any idea? What is the use of saying give retain 2 crores?
Exactly, that's what I am saying.
What is the use of that?
What I am submitting is this. I gave that proposal because I was also not aware at that time that the accounts did not contain that much of amount. What I am saying
Property
is,
security give 2 crores property security and release all.
yes, your lordship may say that.
Sir, property security, what else you need? You want to secure your money and there is a stay operating. And let him furnish a property security of that amount and release it. Take it.
To whom shall I furnish?
You property security where?
There is no charge sheet. How could I furnish before the trial court?
Not trial court. IU only.
I don't think, my lords, it can be submitted before the IU.
Submit before this court.
I'll do that.
What do you say? What do you say?
Money will secure, my lord.
Money, property is there, property. I'll put it on Monday, you tell me. Monday, you tell me, seek instruction, I'll pass that order. Property
Lords,
security.
what I am submitting is this. Your lordship may say that I'll make that property deposit or bank guarantee before the Jagannath temple.
Lordship judgment is.
That's best.
Father judgment.
Judgment I pass.
Yes.
Jagannath temple.
Bank guarantee.
Bank
I'll
guarantee.
deposit with the administration, bank guarantees for.
Very good. I'll pass that out. Read. Hard copy.
Lordship may record that judgment.
Judgment through. Lakshmi Narayan said. Very good. Okay. And let the investigation go on. No problem. Yes. Jagannath temple administration.
Temple administration.
Yes.
Item 8.
Only in respect of, my lord, the release of the.
On deposit, they will write to the IU and the IU will.
The matter will be discussed.
Yes.
Lords, let the main case remain pending.
See,
Otherwise,
I'll
they
just
will
say
not close the investigation.
what can be done.
Interim order, interim application, there is order ka pass ho. There is an interim
I'll
application.
just check it up what can be done. Yeah.
That judgment of Lordship, let me get the reference. Lakshman Srinivasan versus Republic of India.
It is there.
Let the date.
Criminal Legend 660. Your Lordship was
I tried to cut out
extensively in anticipation of all those things, but that will be guiding lines for all the
because a lot of matter can be discussed.
May I please, Lord. Here, my lord, the petitioners are the family members of the opposite party number 2. There was a family dispute, matter reached to the civil court, and there they resolved the matter, amicably they settled the matter. During pending of the civil suit, criminal cases were registered against each other. My lord, the other side also, the informant, the opposite party number has filed another CLMC for quashing the affair against him also.
Where are the parties? Bring them and quash it.
My lord, the petitioner, both the informant, any date lordship fix will.
Fix a date.
Both the informants, my lord.
Both the matters are listed today?
My lord, 8 and 9.
8 and 9.
8 and 9.
Item 10.
Oblige.
Pursuant to your lordship's order, there is a report.
What was it?
The case.
Oh, 109.
109, the basic thrust was, your lordship, out of 100 some odd witnesses, cited witnesses. Only
Last witness was examined 5 years back.
No, recently they have examined another witness in November.
Therefore, I exhort flag.
98 witnesses are to be examined further, out of which they have examined one in November this year, last year. बढ़िया एपीआर क्वेश्चन है काउंटर भी दी चाहिए ऑब्जेक्शन पे भी नहीं बोलते तो नहीं हाँ
Yes. You filed a discharge petition.
Yes.
That is also one of the attributing factor for delay.
And your lordship, there is no provision. Your lordship, there is no provision in the CRPC that after the
PW 54 is last examined. Now 47 witnesses are there. Yes,
No.
Mr. Naik.
Your lordship,
Are you going to examine all the 47 or what?
No, sir, 98 witnesses. Further 98.
No, write down. Total 47 witnesses were examined. Out of total 151.
Sir.
Your lordship, 53
more than that.
151 total witnesses are examined. 54.
54. So that leaves make it 98.
Yes.
से इंस्ट्रक्शन ऑल नहीं हो तो कितने जन के एग्जामिन करियो कौन करियो मुंह तो सर एम्फेसिस दे भी
but let me argue who can't be your lordship
examine all of them 90 91
your lordship there are two issues your lordships let me explain then I'll your lordships bow down to your lordships he has filed a discharge application after charge has been framed and the law is clear your lordship that there is no provision in the CRPC that a discharge application can be filed after charges are framed.
Yes.
Lordship, there are judgments I will file your lordships. I've asked my junior to take a printout
now. This is again?
Your lordships 1989 SCC
my
page.
husband has died.
But let me argue.
Discharge application being rejected.
Yes, disproportionate. But
your lordship, after charges are framed.
Primary concern is delay in trial.
1989 SCC page. Your lordship, 1989 SCC page 1715. I'll file it immediately, your lordships. Once the charge are framed, the accused is put to trial. Thereafter, the accused may either be acquitted or convicted, but he cannot be discharged. This is number one. Number two, your lordship, there is a recent judgment of the Honorable Supreme Court, which I'll file your lordships. 2017 volume 4 RCR. Listen.
Yes. Yes.
Now, lordship, this case is a 3-bench of the Honorable Supreme Court.
And he is giving Allahabad High Court. Very Supreme Court is citing.
Now, Allahabad High Court is the first judgment, your lordships, which has cited the Supreme Court judgments. Second, your lordships, is on a different issue. You are relying upon this judgment, Nirmala. Yes, your lordship, Nirmala's judgment.
Which paragraph?
Nirmala judgment is quite clear, your lordships. I would like to read from the beginning. There are only 5 paragraphs, your lordships.
May I
charge
submit,
sheet
your
was-
lordship?
Read the ratio.
No, no,
read
let
the
me
ratio.
Let me go through the
Let me argue,
references
then
he
you
is
submit.
citing, your lordship, then let me come back to your lordship next week
Yes,
or a
yes.
week thereafter.
Yes, let me cite, then your lordships, you can come back. Charge sheet was filed against the main accused who was a public servant under the PC Act and also against respondents. Accused who are non-public servants under the provisions of section 109 IPC. All the accused were discharged by the London Trial Court. The court of the special CJM aggrieved a criminal revision petition was filed before the High Court. In the meantime, the main accused died. The High Court dismissed the revision petition on the ground that the death of the main accused has resulted in the abatement of the trial. Therefore, nothing remained for consideration. I agree with the present appeals have been filed. Having considered the decision of this court and upon hearing the learned counsel for the party, we are of the view that the death of the main accused does not result in the abatement of the trial.
Para 4.
Para 4 and 5, your lordships. Only 5 paragraphs, your lordships. 1 week is not necessary because only 5
Para 4 is
paragraphs.
directly covered.
Yes, directly covered.
You seen it, Mr. Sadagi?
Sir,
Have you seen it?
I am looking at it, your lordship. He was kind enough to hand me over. ମୁଁ ଦେଖିନଥିଲି।
I had asked him to first take out a printout for Mr. Sadagi, your lordships.
ନା ଏବେ ଦେଲେ, thank you so much.
Again.
Don't have a case now.
I have got a very good case, your lordship. Case apart, 98 witnesses, now 20 years gone.
I'll direct for expedient.
Let me take instructions, your lordship.
That's the only thing I can do.
If this is what your lordship is going to do, let me take instructions.
But the
week or
prayer,
the
your
week
lordships, is
thereafter.
limited. Your lordships,
What
prayer.
instruction?
No, I am also equipped with certain distance. I will share with him.
But you will seek instruction whether the court should direct.
No, court is free to do whatever it does.
So I'll pass it that order, but
Yes,
Not that.
this direct, see, the judgment is up for 2000, 2017. judgment.
16, 17.
17. judgment.
There is another judgment by the lawyer was telling me this morning. That's the problem. He couldn't take note of it.
Correct? Put it on
The matter may
Monday.
be listed tomorrow.
Monday
your lordships.
is not a good day, some other day.
Tuesday, good day.
Tomorrow is a good day, your lordships. Tomorrow is a very
Tuesday,
good day.
good day for him.
Tomorrow is Thursday.
Thursday doesn't.
हाँ,
Thursday is a very good day. Tomorrow.
Monday टा साथ के रही जाए एयरपोर्ट सपोर्ट काम तो
Thursday means tomorrow it suits you.
Tomorrow is good day. your
tomorrow
lordships.
not tomorrow
Day after tomorrow.
not tomorrow
Not tomorrow also doesn't suit you.
no
Day
it's
after
all days are good days
Tuesday. Okay. 22nd.
all days are good days
22nd. Okay.
22nd, your lordships.
But he directly covered what to. I'll expedite the trial and Mr. Naik. Meanwhile, see, you also seek instruction from the prosecutor whether you want to examine all of them. May not be.
that
And
he
the
can't
delay
say
is not
now.
applicable.
Now question is lordship your fix is 6 months or 1 year, let's say I'm 68 years of age.
That's it. Leave it to me. Depending upon.
So supposing it will be never complete, so then my lord, what it cannot be lordship may cannot be.
Hypothetical question, your lordships.
It may not complete. Therefore, I will pass. That's not.
No, it's a
So one
question
small
of
request, your
this
lordships.
case for delay in trial. And if your lordship will look at the all 161 statements and the evidence recorded so far, nothing remains there.
See, then
That the
we
trial court will
have to
decide.
go into the attributability factor.
Then
You
your
have
lordship,
moved an application for discharge. You move an application for going abroad. All these things I will have to take into consideration. Then the expeditious disposal is also that order also cannot be passed.
no,
If I'll go into all.
next your lordship may say it is not a mini trial, I can't conduct. That is also equally correct, your lordship.
Therefore,
There is another.
Let us be practical, and I'll take it up on.
I will place 2 or 3 statements. Your lordship will see for yourself, my lord. No case is made out against me.
Can I go into?
That is the problem. That is what the
can't do that.
hindrances. Yes,
I
because
can't do that. That's the problem. Now,
now if court can't
cases
protect,
are examined. At this stage, I can't go into all this. And
At
the
least
judgment is staring at the face of it.
let the court not be a party to extending litigation, my lord. Let it close somehow. So 6 months, 1 year.
Court is
Lordships, blaming the court, your lordships.
Trial court is expanding the scope by taking 4 years, 5 years, no witness.
We'll see.
One small request, your lordships. Your lordship, one small request. The judgment which sir was citing, the advocate gave today morning. एक advance copy may be given to me so that I can read it beforehand.
Yes, give that.
सकाळ जुड़ा.
Yes. Here.
My lord's judgment is there. Of course, that was trial was not on then.
That's the difference.
109 trial was not on.
Yes. It is 13. Yes.
Please, yeah. Per hour.
Yes.
Not sir. The petitioner is the wife of the main accused in a PC act. She has been implicated for the offence under section 109. Not sir. There are one property standing in her name worth rupees 90,000 and some deposits. And she made a statement on oath before the IO stating that all these things have been done by my husband and I have not acquired anything of my own source of income because I don't
Where
have
is
it.
that? Where is that?
No, that is at Annex 2 Millers.
Annexure
2.
item, which item? 13.
Annex 2 at page 57 Millers.
61. 61 or 11.
No, it starts from page 57.
Yes.
Statement by affidavit before the IO. It was submitted as long as 2016. Well, CC's page 61, where she has specifically stated, paragraph 3, page 59, that I voluntarily state that I had no knowledge about the sources of income of my husband, except the fact that he is serving in such and such corporation, Baripada Pen. I had no knowledge about the quantum of income of my amount of salary, other things, and specifically,
Okay, this affidavit is shown on.
2016, 29/7/2016.
Let us see the charge. Come to the charge.
Charge sheet is Annex 1,
What are the agreements? Yes. Yes. How many properties are there?
Yes, if we count in view of as far as the instruction is concerned, in your lordship may refer paragraph 4 and 5 of the statement. That is covered by your lordship.
The judgment of your lordships.
That he has given on affidavit during course of investigation. So your lordship may refer paragraph 4 and 5 and dispose the matter in view of that instruction of.
No.
Because your lordship's judgment is very clear.
She cannot dispute them now.
Please, let us see what is the charge sheet.
109 only, Lord. So far I am
Let us
concerned.
see whether she has she put forth any defense. Then why should she face the trial? No, you may say whatever. I'm not on that. Then he's directly covered by the judgment.
That's your lordship's judgment.
So then what are you saying? This affidavit may be treated as an evidence and he face the trial.
Because she has given it on by your.
She is doubly assured. Now she is not putting forth any defense. This is for sure. And over and above that, she is giving an affidavit. What else you need to be covered by that judgment? With
Yes,
that judgment,
yes, I am giving you lordship. Paragraph 7. Please, Lord.
That's why I am telling that paragraph 4 and 5 your lordship may refer and.
Relying on judgment, of course. See, let us see the charge sheet first of all. Charge sheet. Has she put forth any evidence? Defense?
No.
His wife abetted the only one time. Para page 56.
Is a quashment. Is a case.
Yes, same, Lord.
Where is that portion, Mr. Maharana?
His wife, page 56. Your affidavit.
No, the charge sheet.
Charge sheet, his wife, Suprapal, abetted the commission of offence by assisting Paul to acquire the deposit asset. Page 56.
56, huh?
Fourth line.
From the top.
Fourth
case.
Paragraph.
From the above calculation, the accused is of such and such, then 3 lines below. Srimati Supravala.
It is there is one of the accused along with husband. What is his name? Suranjana.
No, Suprabha.
Suprabha Paul.
No, husband's name.
Suranjan Kumar.
Suranjan Kumar Paul. Along with this petition has been arranged and accused. Accused, along with the husband, Suranjana Kumar Paul, for alleged commission of offences punishable under section 13(1) E of PC Act, 13(2) and 31(3) of PC Act 1988. Mediation section 1 of ITC. The petitioner has been implicated in the proceedings under the aid of section 109 ITC on the allegation of harassment to commit substantive crime by her. After investigation, charge sheet has been filed in the present case on the only allegation which reveals from the charge sheet is that the petitioner is present for commitment to the offence. Except that there is no evidence coming forth to substantive case. The relevant would be to reproduce part of the charge sheet which indicates page 56, paragraph 8, will be the paragraph from the above to the the it is admitted by the petitioner has not put forth any specific defense defending income, specific defense of their own. She has already stated and she has also stated that she has no income spare, and she has also filed an affidavit before the investigating agency. What is that affidavit? Investigating agency. On 29/7/2016, entry stating as an para 4 and 5. Para 59 is 3 and 4. No, 4 and 5. 4, 5. 3, 4 and 5. 3, 4. The investigating officer is not taking into consideration the statement made by the petitioner to the affidavit, and when they are filed the charge sheet against the petitioner under the aid of section 109 ITC. A notice was issued to the vigilance. Pursuant to the notice, the special PP vigilance furnished a written instruction to the through the SP vigilance. Letter number special PP vigilance to the SP concerned SP has filed a written instruction, submitted a written instruction. Also refer that number instruction dated 10/4/2025. Mr. Maharana has placed on record the same. The contents of the instruction 37. On the above factual conspectus, on the basis of above factual conspectus, Mr. Samantray, the counsel for the petitioner submits that the case of the petitioner is directly covered by the judgment of this court reported in 2024 1 OLR 616. That is E. Swarnalatha alias P. Swarnalatha versus State of Orissa. He has emphasized on paragraph
7 onwards.
Para 7, huh?
Yes, sir.
Para 7 to 9. Para 7 taking this consideration, the material for on record, the charge sheet, the document on part of the charge sheet. And, in the light of the factual scenario, the judgment of this court is analyzed. the apparent on record that the petitioner has very specifically ever in the affidavit that she has no knowledge regarding the let's say the harassment of the asset by
Only deposits.
husband, and she has also not put forth a specific defense to justify the disproportionate asset amassed by her husband.
Husband.
Her husband. It is her husband who has to explain the disproportionate asset. Disproportionate asset acquired by him from source support, the legitimate source support. Therefore, the petitioner cannot be prosecuted under the 8/109. Hence, the case of the petition is directly covered by the judgment of the therefore, the fire number 4 and the constable has in their account who are the petitioner. What? I have, this court has not expressed any opinion regarding the merits of the case insofar as the principal accused, the husband of the
Lordship, she has got that fiduciary relationship. That's the important line in lordship judgment.
That your lordship was held specifically feudal paragraph, I think 6 onwards your lordship is specifically stated because
that I have
affidavit भी से लिखी थी. Only
para 5. Para 5. Para 5. Para 5 I place.
Lordship taking into consideration the peculiar fact and circumstances.
always facts are peculiar.
Constructive entire I have made that observation. I am not expressing any opinion so far as the principal.
So about our opinion, for a collect got which also then. I will take it back later on.
5, 7, 8, 9. Yes.
In the affidavit में para 4 and 5 lordship.
Yes. 3, 4, 5.
3, 4, 5. So
Yes.
said 3, 4, 5.
Yes.
Great.
Item 14. May I slip from that? That is, my lord, promise to marry. A consent has been given. Both have major minor. Thereafter, after the victim has denied to marry, he has the active person has taken marriage. There after 1 year.
And issue notice later come.
My lord, I just Supreme Court decisions also.
Must he make up a mind to marry you now?
Okay, sir.
Already petitioner got married, your lordship, and earlier bail
He has
application
already married somebody.
chakri padeva, plural marriage.
Supreme Court decisions.
That is issue notice. 376.
Your lordship.
Yes.
Bail application rejected, anticipated bail, your lordship.
He is in custody.
No, it's an army man.
Bail application rejected. Anticipatory bail.
Yes, your lordship. 3/2/87/2025, your lordship.
He has not been arrested so far.
Yes, your lordship. Now he is in service place.
What can I give you? Investigation has already been completed.
No,
lordship.
completed.
I can't stop investigation.
No,
Your anticipatory
I
bail.
have also cooperated with the investigation.
So then what can I do now?
My lord, no corrective action.
What no course action?
Against the petition.
Because your anticipatory bail application is rejected.
No, that is,
I
that
can't
is separate.
supersede that order.
Okay, ठीक, my lord.
I'll just issue notice. I
That
can
is-
give you a short date. Would go into with the court here and file the process fee and serve.
Yes, sir.
And serve through IO also.
Yes.
Serve through IO also. So that we can take
Definitely.
time. Yes, he'll give a date. Wait. 16.
And 17. Please, my lord, here, petitioner is the husband failed to quash the proceeding because the wife has also filed a complaint case in the year 2004. Now already 21 years has already been elapsed and wife has also started her.
There are 6 petitioners. All of them are husband.
No. Saurabh Chandra Behra is the husband, sir.
Petitioner number one.
One, sir, is the husband.
Like
Now the wife started her second journey after marrying to another husband and also leading a happy conjugal life. That is there. Only the case is pending, nothing. So only let the notice be issued. Let the lady to be appear.
What are the offences? Let us
All 498 is there, no?
Okay,
Sir.
okay. Issue note.
Sir. I want to stay up further. Stay up further.
You have not said what is the state.
No, nothing has been happened. Because since 2004, 21 years has already been elapsed, sir. Nothing.
Nothing means charge sheet has might have been filed.
Charge sheet has been filed.
You where have you said you have not filed anything? That's the whole difficulty. What have you filed? See the annexure. What have you filed? How will I know what is going on?
Entire case, sir. Entire case.
What will I say now? What will I say?
Let notice be issue. Let a short date may fix. Let the lady to appear.
But I don't know where is the case pending. Nothing. You have filed nothing. Yes. Anyway,
Sir.
issue notice.
Sir, oblige.
Bring
Short date may fix.
Bring them.
Yes.
Item 18. Item 18, may I please, my lord? I am on VC, my lord. Here the petitioner challenges the order passed in Criminal Division 2 of 27, thereby confirming the order of the learned SDHM Court into taking cognizance against the petitioner for the offence under section 3762. Your lordship may kindly have a glance to please enough to come to page 64 for a moment.
64.
Yes. Annexure 3, my lord.
Yes.
4 line from top, on perusal of the charge sheet, it is found that there exists prima facie material against the accused persons for commission of offence so and so and so. Hence, cognizance has been taken against the accused persons for offence under section so and so. Now, your lordship may kind enough to see page 17.
70.
17.
Yes.
70.
Yes.
Running pages. Annexure 2, page 70. Running pages, page 20, my lord.
70 you are talking about?
17, Annexure 2, 17, page 20. Running page 20.
Okay.
Running page 20. So the petitioner was charge sheeted under section 312 only.
Where is that?
That is page 20 of the charge sheet file is column number your lordship XVI. 16 column number charge sheet 312 IPC से charge sheet को ले but cognizance and taken under section 276 2N 312 506 294 34 that was under challenge before the filing the revisional courts confirm the order passed by the London SDGM that is under challenge
Taking cognizance.
yes but
and for your lordship posted for appearance.
The materials against him.
yes sir, there is a material lordship.
Nothing on record. Your lordship may kindly see.
The present petitioner is also one of the abetter lordship. Kindly glance page charge sheet file 22 your lordship.
24 for a moment.
22?
Yes, your lordship.
Yes.
May I read your lordship the relevant page your lordship?
Yes.
Person lordship. The first paragraph lordship. The present petitioner names your lordship is Kunni Rao. Alias Didi alias Dei your lordship. The present petitioner's involvement is that he is abated. Your lordship, may I read it? Mongol Kadma sent Kunni Dei. Mongol is the principal accused. Sent Kunni Dei to the house of the complainant and reaching at the house of the complainant, she took the dead child with her in a plastic bag. After the incident, the relatives and the family members of the complainant could know regarding the incident, and when asked regarding the matter to Mangal Kadma.
The allegations are very serious.
Yes, your lordship.
Kunni Dei forcibly tried to tie the hands of the complainant. That is, elicited injection on her. And also they
Page 24 for a moment, your lordship. That was the brief fact. Page 24.
Yes.
Page 24, 21 lines from top to bottom. The main accused was Mangala Kadam. That was not disputed. Mangala Kadam kept relationship with the victim. Consequent upon which he again kept the relationship with the victim on the false premises of marriage. When he came to know about the pregnancy of the victim, he took, your lordship, I am just citing the relevant paragraph, your lordship. Then Mangala Kadam approached Jambati and took her with him on motorcycle directly to the house of Kunni Dei, situated at so and so.
In the middle you read.
Yes, the Mangala Kadam
insisted. Then Mangala Kadam insisted Jamavati for miscarriage. And
after
after the motivation of Mangla, Jamavati agreed for miscarriage and then took the help of Kuni the Rao.
yes,
For
for
which
which Kuni the Rao administered
admitted the injunctive to
Yes.
her and also gave her appeal to take and from the three zones.
So at best, I am covered under section which was rightly submitted by the investigating agency, Your Lordship.
Yes.
So at best, I am covered under section 312, which was rightly submitted by the
Argue
investigating.
all these things you can argue at the stage of framing of charge, not at the stage of cognition.
At least my lord may protect me because I am the case was posted for appearance, Your Lordship. And since the cognizance was taken against accused persons, there are every likely chance because in the charge sheet itself, 3112 was adverted against me.
You move application before the trial court.
Your Lordship may protect me.
I will the point. Right. The petitioner is agreed by the order dated 17/11/2023 passed by the legislature additional specifications as Koraput in criminal division number 2 of 2017, whereby the order of cognizance order dated 28/11/2016 passed by the legislature Nyayadhikari Gramalaya.
Order was passed by SDGM Koraput. Your Lordship, the order was passed by SDGM Koraput.
Cognizance of offense under section 276, 2N, 212, and 506 of dispute 90 for IPC taken upon by the EPON, has been upon. Mr. Hon'Ble and counsel for the petitioner has taken me to the charge sheet and submitted that the initially the charge sheet has been filed against the present petitioner IPC. However, the High Court while the order dated 2011-2016 has taken cognizance of 312 and 506-294 of this 34 I think. The order has been challenged by the petitioner before the revisional court. Revisional court. The cases that additional cases that Jaipur has rejected the revision petition, thereby affirming the order for the GAN taking cognizance of the offense. And he has also read out the form, the part of the charge sheet to substantiate. I have carefully gone through the contents of the charge sheet and the clear form part of the charge sheet. There are certain allegations that here which prompted the court below to arrive at the ground description that the offences are made. At this stage, this court is not inclined to analyze the nature of the evidence placed by the investigating agency in the form of charge sheet. It is open for the petitioner to urge all the points before the court below the stage of opening of court. They are open for the petitioner to move specific application in that regard. If such application is moved, the same shall be considered. Yes.
Till then, I may be protected, my lord. Till then, I may be protected.
What? How can I protect you?
Because the case was posted for appearance, Your Lordship.
Then appear. What is the big deal about appear?
Because cognizance was taken against the accused persons for the said offences, and I will submit. Your Lordship directed, I will submit to that effect.
You have to move application for bail.
Yeah, for that reason. And one more submission, Your Lordship. The order was passed by Additional District and Session Judge Koraput, Your Lordship, not Judge. Koraput. And initially, the SDGM Koraput took cognizance, and the presently it was pending before Gram Nyale after transfer of the case.
19.
May I, Lordship?
Yes.
Lordship, petitioner challenges petitions having a business account. 3 lakh rupees has been settled by the opposite party number 2. There is no complaint, no FIR as against the present petitioner. Rupees 3 lakh has been settled by the cyber PS. and subsequently filing of this case and
What are you asking here? Kindly please to admit the case and issue notice to the opposite party so called as to why the case of the petitioner shall not be allowed. And,
What the remedy is there?
Yes.
opposite party number 2, they freeze the account of the authority, so on, so on, so on. Or your account has been freezed.
Lordship, there is no complaint, no FIR.
It is very premature.
Lordship.
There must be something.
I have annexed my account details. I have a taxpayer.
The investigating agency might have informed the bank to freeze it because there must be some suspicious transaction in your account.
Let's say account has been not freezed.
Ask the bank. Have you asked the bank why who has done it?
Inform me, Cyber PS has been settled the amount of 3 lakh rupees. Now, after filing of this case, they would run the same.
Then it is part of investigation. I can't detail it.
Let's see any notice has been.
Lordship, there is initial stage, Lordship, could not be ascertained the
But
amount.
he is
whether
entitled to know why who
Yes,
is
that-
at whose instance.
And now, his account is maintained by the bank before the HDFC Bank, Lordship. And his every.
Some
That's
some
why-
investigating agency might have informed the bank.
Yes, sure, definitely,
freezing it.
Lordship, that's there.
He wants to know who has done it.
But he has
That is
every
which
right
case?
to obtain the information from the bank, whether why my account has been
That's
freezed
what
by
I'm
this
asking.
account.
Have you
Yes.
asked the bank?
Lordship, only interpretive Cyber PS has been settled.
Where have you said that?
Lordship, orally intimated us.
No, where? You have to ask the
No,
bank.
Lordship, there is no FIR, no complaint has been issued.
Who is there? Bank? Which bank? You have included whom?
HDFC Bank, Lordship.
Okay, after that, the company said.
You have implemented opposite party number. Why have you implemented inspector of in charge?
As per
ADCB, cybercrime branch, so and so.
let's be as per instruction of the bank.
But you go and I'll give a direction that he will inform you. I'll give a direction that he will inform you and which case this has been done. Isn't it? That petitioner is petitioner has filed the present petition seeking the indulgence of this court for a direction to defreeze the account which has been frozen by his banker. He submits that he has no clue as to under whose instruction the bank has frozen the account. However, in paragraph, which paragraph you have said? CBCID? Where have you said?
Page 5,
Lengthy paragraph 3, the last one, page 4, your Lordship. Company said. Paragraph, page 4, your Lordship,
Yes.
petition, Lordship.
However, in the petition, the petitioner had covered regarding to the regarding to the government made the petition and the fact that the petition is not aware the bank has been frozen. It is the police department to the directed to inform regarding the case. Or immediately not going to the bank is has been frozen. They are report to the right remedy available to him under law. Which is observation the petition.
problem.
20.
No, this is a Belgium matter.
NBW judge issued on
13,
13, 12.
12 to 2024. On that day, the petitioner was suffering from gastric.
NBW was issued on 13, 12, and 24. Bail was allowed on 21, 11, 2014, your Lordship.
14.
Yes, your Lordship.
Okay, 5. Yes,
21.
Well, the input order is under Annexure 4. It is running page 24, wherein the amendment petition filed by the petitioner, complainant for the landed court bill was rejected.
Amendment petition.
Yes, my lord. The complaint case arising out of NI Act. And my lord, the PW1 has not yet been completed. Cross section of the PW1 has not been completed.
What amendment do you want?
Amendment I have filed to implement the company because demand notice was issued prior to filing of the complaint
Where
case.
is show me the demand notice?
Running page 11.
You had issued notice to demand the bank, sorry, company.
Company.
Where?
Running page 11, annexure 1.
Yes.
Demand notice sent through mail to info@kupalusteel.com.
Where is it? Monmay Vasu.
My lord.
Mail.
Through mail, my lord. Because at that time, Corona was.
Where is the legal notice? How can I open it?
The demand notice against the check amounting rupees heading is there, my lord.
Show me that PDF.
Then next page.
But here it is only Sabyasachi's house. Where is the company?
My lord, those notice, demand notice issued to the director, that was sent to the company through mail, my lord. In both ways, by registered post to the director and through mail to the company address, my lord.
Company name?
That Krupalu Steel, madam. Krupalu Steel. The company name.
Where is the there is no forwarding letter, nothing. What kind of mail?
My
You
lord,
wanted to now, where is the complaint? Where is the complaint?
complaint.
Initial complaint.
Complaint petition I have not filed, but I have filed the
Show
amendment.
me initial complaint, whatever the amendment made. Unless you show me the initial complaint, how will I appreciate what amendment you are seeking? Whether in the complaint, have you made any amendment regarding the company? Initial complaint.
Initial company just my lord, because the petitioner is a small businessman at Kotak and the company is at Jaspur. And repeatedly, yes.
Sir, you are seeking an amendment to 138 petition. You are saying that I had given notice to the company and as well as director. Inadvertently, I have not implicated the company, but only director. I want to bring director as an actually company as an accused. That's what your case is.
Yes.
Let me see the original complaint. In the original complaint, what allegation you made against the company? Where is that? Unless I see that, how can I allow your amendment?
Your lordship may tag this matter. My lord, the opposite party has already filed a case by challenging the cognizance order. And your lordship has issued notice in CRLMC 958 of 2025.
Issue notice in this matter and tag with the, yes. Tag it, yes.
CRLMC 958 of 2025.
Yes.
Madam.
22.
22, my lord. Lordship may kindly have a glance annexure 4. In respect of one of the co-accused, Lordship has disposed of the matter. So similar prayer petitioner has prayed. So may I read?
Whatever I say.
Here, my lord, earlier anticipatory bail was granted and a lordship has given the liberty if you surrender with
Where is your anticipatory bail? Same order. Same order.
annex. Yes, same matter. Same order, same co-accused. Annexure 2 is the previous order where he was the co-accused. Annexure 4 is your lordship's order. Similar prayer.
Similar prayer.
Yes.
Yes.
Lordship.
In your case, when the anticipatory bail was rejected?
Lordship, that
Annexure 2, my lord. Annexure 2.
18/5 then 22, your lordship.
Yes, here also 24 lordship was granted because
coordinate bench when in your case when
both the petitioners Sujit Gowda and Prashant Naik, your lordship, that is there.
Annexure 2, my lord.
Here is Sujit Gudia.
The lordship has granted to Prashant Naik. Now present petitioner is Sujit.
both okay.
Yes.
Same order pass. Annexure 4 time.
The date they will see date with us. And lordship 23 and 24 is sorry, my
Third paragraph the date change whatever. Resubmit that. Then counsel for the petitioner submit that para 3 type of para 3 type para 2 type para 3 then counsel for the petitioner seeks to withdraw the present petition so as to avail the benefit of the order dated 18/5/2022. He submits that the client is appearing surrendering before the court below on or before 28 bar of the in the Kudival on or before 5/5/2025 and avail the benefit of the order dated 18/5/2022. Criminal MC is put up, but this goes up to the direction to the petitioner to appear public surrender before the court below on or before Panch of the policy and avail the benefit of the order dated after Panch passed in BPL number 3580 for 24. Okay. Yes.
Obliged.
23.
23 and 24, my lord, in respect of the same petitioner, a compromise on the basis of compromise and praying for quashing, my lord. 307 injury is simple. I need to take notice. Short date may be fixed.
24 that is 23, 24 simply is notice. Yes.
Short date may be fixed. They will appear. Obliged.
You bring them, we will see. Yes.
Yes. Yes.
25.
May I please?
In this case, I am appearing for, I have instructed to appear for opposite party number 2. Case is counter, I have filed one reliance matter. Case is counter, compromise is there, matter. Let it come along with the reliance 1465/25.
Issue notice to opposite party shown to enter appearance on the advance notice. Please this matter along with shown.
1465/25. Obliged. Next week, ma'am.
Will give a date. What are the offenses?
1009 3075 is matter.
What are the injuries?
Injury is simple. Body ଖେଳକୁ ନେଇକି ଦି group ଦି ସାହି ଭିତରେ ଗଣ୍ଡଗୋଳ ହେଲା. Simple injury, compromise was made between them. And now they are fully well married. ଭଲରେ ଅଛି.
Yes. 26.
10/2/2023 ମଝିରେ ଆଜ୍ଞା ସେ ବାହାରେ ରହିଯାଇଛି ବୋଲି
19/4/2024.
27.
27/3/2024. Three dates are there for them. 22/2024, 29/3/2024, 8/4/2024. NBW all NBW bar
3 all the three.
Yes.
My lord. Four persons. 4 different dates. Wait.
My lord, on behalf of Mr.
NBW to the party. Each 500.
28.
Lordship, without issuing notice, lordship shall delay issue annulled by the land trial court, lordship. There is a bail जाइनी मु lordship बेटे जमा मुझे वहाँ जानी नहीं मोना रे वारंट इशू करचंदे it without issuing notice, lordship.
para 3 रे बेर जाय छै
bail जाइनी lordship सब
Absconding.
मु bail जाइनी lordship लिख दे तो
What is your name? What is your name? Sibo
Sivaram, lordship. Lordship, kind Peru Janis one, lordship. Another Sivaram Swine Sibo is absent. SR back with the report that no one could identify the same accused. This is a case of a desert bar.
Proceedings dated bar of doing the potency arising out of Chittaranjan case number 296/2012. In 2012 or what? 2012. 2012. Yes.
Lordship, warrant. I'm going to set aside, lordship. Any rule set aside, I'm surrender, lordship.
I've done it. 29, 10th, 29, 10th.
Imbue was
29.
NBW was issued on dated 10/9/2024 and he was on bail on 2/1/2024, my lord. I have stated in my
124.
yes, my lord. In paragraph 3, I have stated.
Yes. Yes. 30.
NBW was issued on 5 of January 2024, but he has to appear before the court. Therefore, the
NBW, 1 CC case. 1 CC case. 31.
Well, in this case, the plaintiff has filed the CMP against the rejection of the petition filed by him to recall the Amin Commissioner.
Recall?
The Amin Commissioner. So against that rejection order, the plaintiff has filed this CMP, praying to was the same, giving liberty to the plaintiff petitioner.
No, it was dismissed for non-prosecution.
It was, my name was Bhubhuti, it was written, thereafter I missed.
For only restoration.
Thereafter it is restored.
Restoration only.
It is already restored.
So where is it? Restored by which order? Which order?
I filed the
It was dismissed on default on 14/3/2022.
my lord,
When?
it was restored CMAPL 144 by 2022 by order dated 13/7/22.
13/7?
22. CMAPL 144 by 2022.
That order is not here. Anyway, it is now, you tell me.
Restored by order dated 13/7.
Yes, it is restored. According, I'll take it. Restored. Yes, you tell me. What has to happen?
So my humble prayer to set aside the impugn order, giving me liberty to cross-examine the Amin Commissioner.
Which impugn order?
My lord, the impugn order is at Annexure 8, page 40.
Yes. What do you say?
The Law and Trial Court has referred to a decision of the Honorable Supreme Court and has held that the provision, it is at page 42, running page 42, referring to that decision, it is held that the provision of orders 18 Rule 17 is a discretionary power of the court, but be used fully, sparingly, and in case the court decides to invoke the provision, it also see that the trial is not unnecessarily protected on that ground. So in this case, as this is a suit of the year 2010, and
What is the stage of the suit now?
my lord, it was stayed by the London District Judge in FAO. Now that FAO has been disposed of very recently, and now the suit is for hearing.
So what is the stage now?
Now the stage, the plaintiff is to give evidence. Plaintiff has not yet given his evidence. I am for the plaintiff. So under such
Notice
circumstances,
was issued.
last date she took time.
Anybody appeared?
Through VC she took time. Last date through VC she appeared and took time. My lord may kindly see the last order.
Last order kind.
The other side took time.
This is the matter on 16/4/2020. That's all. Who appeared? P. Panigrahi. Pass it over. I'll allow it. It appears you moved an application for
To recall
under order 18 Rule 17. Cross-examining the Amin Commissioner, which has been turned down.
For
On the
further
ground that you moved application after 1.5 months.
My lord, the Amin Commissioner submitted his report in respect of the suit property. Both the sides, the plaintiff and the defendant, has also made counterclaim in respect of the same property.
Where is the Amin Commissioner's report and his deposition? Show me deposition.
My lord, deposition, I have filed the objection by both the parties.
Show me his deposition.
Deposition, my lord, I am not annexed.
Do you have the copy? Why have you, what are you going to ask? He suffered cross-examination,
My lord,
extensive cross-examination. Why are you seeking him once again?
my lord, only one thing, both the sides claim the self-same property as belonging to them.
That's
And
right. What are you interested to ask him?
I want to ask him about the measurement.
In the application also, you have not said anything.
In that application, when the suit was transferred from Puri to Niali, the new council found that
Come to the application, it's page 36. What have you said?
my lord, the application is at Annexure 6, page 36.
No reasoning, nothing.
Sir, he had given the para 2 that it is unfortunate that while
That he says that the advocate for the plaintiff has not cross-examined him fully with the wrong notion that the Amin corporation examined as a witness on behalf of a defendant number so.
in the IA.
Show me his testimony. I want to see.
My lord, whatever there.
I am passing over, get it.
My lord, I do not have.
This is minimum document. Unless I see that, how can I allow you?
I have to call for from Puri, my lord.
I don't know. This is pending since how many years? Just see.
No, it was
dismissed in default. See, this matter is pending.
because
This is
of
wrong.
the wrong spelling of my name. I list the miss.
That's right, but now it is restored.
No,
At least you should have those documents,
my lord.
which are the relevant documents. Unless I see that
My
document, how
lord,
will I allow?
the ground stated in the petition that wrongly the counsel at Puri, he cross-examined thinking that it is.
Why should I believe I don't without seeing the document? After your application is rejected, I want to see whether whatever your lawyer has said before trial court is correct statement. The court has rejected your application.
Rejected on the referring to the decision that it cannot be when the suit is of the year 2010, but that decision itself supports me. I have got that decision.
Therefore, you just show me if you have the testimony, just show me whether you have cross-examined or not. Because see, I have to allow expertise. Nobody is there.
My lord,
I'll pass it over. Let him come.
so I have to call for from.
If he doesn't have serious objection, I allow it. Fixing a particular date for the purpose of.
One day, only one day, my.
So let him come. If he doesn't have a serious objection, I'll allow it.
Only one day, my lord, I may be given. I will complete.
Pass it over. Pass it over. Call the other side lawyer if you can. Please call. Let him come. I'll just come.
$72 मतलब compromise matter मतलब present there.
72.
72
Parties are there.
Yesterday they are present, my lordship, and your lordship was directed to file a joint affidavit.
Yes. 72 order को नहीं Have I dictated the order?
No,
My lord.
no, my lord.
Pass.
Pass over the document.
Very good. Dictate to dictate కూడా. Poetic action. Yes. Acha, victim has been implemented.
Yes, my lords.
By the order dated. But instance of opposite party to the fire petitioner. After investigation, charge sheet in the present case has already been filed. Pursuant thereto, by the order dated 6/2020, by the order dated 18/9/2020, the Federal Court of Orissa in VR case number 38 of 2020 has taken cognizance of offensive punishment under section offense punishment under section 376 2 F and 1 F and before the charge is placed and trial commenced, the parties have entered the petitioner and opposite parties are the father of two is opposite party number 2 is also the parties have filed a joint affidavit before this court in India. 1 to 5. 1 to 5. So, what is the terms of settlement?
The victim married to someone else, my lordship, and she has a child also.
Okay.
Before
What
also,
about the petitioner? He is working as?
My lord said not unemployed, my lord.
No, yesterday he was working.
No. She was working as a supervisor and crosser, but now not working, my lord. At the time of the occurrence.
I know, yesterday he was working. Today
Yes.
he is not working. Because yesterday you said that I said that I'll impose cost, then today he have become unemployed immediately overnight. Yes. 1 lakh rupees has been paid.
Yes.
That's what
Yes,
he said.
yes.
Out of 4.
Yes. Some more can be.
It's this party is number 2 and my father what we did for what said the party is down right and the party are the petitioner is 45 years and what is the age of the lady?
Sir, 43 or now.
43.
Victim.
43.
Now 43 years.
Petitioner is part of the department. They have taken a conscious decision to put quite a therefore there is no legality. Now, our 164 records which it also there is a statement of the record 164. But they have increased that the opposite party was and now petitioner and how much cost will be?
The girl child, because out
Girl
of
child is there, 50,000. 50,000 rupees you have to pay. There is a girl child from the marriage. Victim girl child ke do. I am not writing all this thing. But from this relationship, there is a girl child.
yes.
30,000. Okay, 30,000. Subject to petitioner paying rupees 30,000 rupees from the cost. Pay 30,000. Over and above the agreed amount. That 1 lakh, I am not saying that. Tell her that.
Yes.
Tell her that.
Yes.
Call her and tell.
Yes, ma'am. Sure.
32.
Petition was dismissed for non-compliance of the peremptory order. And it was dismissed on 29/9/2014.
How much delay?
The delay is more than 5 years.
More than?
More than 5 years.
5 years.
Yes. That you are suffering from some diseases and he has given the medical certificate.
What disease?
It is a property dispute.
Who was suffering?
The person who was looking after the case, and he has to supply some certified copy of the orders.
For 5 years it took. What was the disease?
Where the disease
What was the
was-
disease? Where have you said what is it?
CVA 1 at right side, hemiplegia. I have the medical certificate is accompanying this copy. Some disease hemiplegia. Then 23/8/2014 to till date under my treatment.
When was it? When the petition was dismissed?
Yeah.
Dismissed on recall of order 29/9/2014.
Yes.
And you are suffering from?
Suffering from hypertension, CVA 1, the right-sided hemiplegia.
Oh, hypertension is a disease.
I do not. So far as the hemiplegia, I don't know what kind of paralysis.
Hypertension.
Hemiplegia.
Where is hemiplegia is not there?
Yes.
It is hypertension.
CVA 1, CVA.
Where is that?
Right side in the medical sector. He has given the medical.
Annexure?
That is annexure 1.
Annexure?
1.
1 to your application?
Application CMAPI.
Application. Okay. Maybe. Okay. So is that the certified that
Yes, it is there.
suffering from?
At page 8.
Potential CBE right immediate semi-failure. Hence, 2000 days. Till date means 30 days. 49 without 30 days.
Delay is, I grant that.
See, the certificate is given 23/8/2014 to 14/9.
4/9/2023. He was under treatment from
Yes, who is appearing?
23/8/2014
Who is appearing?
till 4/9/2020.
Notice has been not been issued.
No.
Okay, as you
No, no.
notice on the IA as well as the petition. Let them come. Issue.
33. In this case, I have the file number, same way. 114 out of 24. In this case, notice has been issued to the opposite parties.
Who is appearing? Service.
My lord, notice is issued to opposite party. 1356.
Are you appearing?
I am appearing from respondent number 1 and 4.
How much delay? Delay. Delay in filing application.
The RS was dismissed. Thereafter, they filed same appeal. That has also been dismissed. Thereafter, present same appeal has been filed.
First example I have filed. Under that only 235 notice are not issued due of notice. I have not filed 1 week. Requisites. Then I again cases were listed of listing of property. I am not present in the exact date. The case is dismissed. After that, I filed the second stage. This is the case of notice. One.
It suffers, this petition is suffering delay.
Only 30 days. Within 30 days, I filed.
30 days.
That was in time. Current data I am giving.
Yes.
I am giving. Admittedly, there is no delay.
Okay, there is no delay. Date chart, let us see.
Data I am giving.
Let us see this.
File. Some of the times application
Who are present? Second appeal, RS of the year 2007.
How many CRLP you have filed? I don't know. How many times it is dismissed?
Madam, one time is
No, you file a CRLP, that CRLP is also dismissed. Thereafter you move after restoration application, that is also dismissed.
Madam, you look only.
How much interest that court can give you?
Advocate name. This is the advocate name. Order of minor. You can advocate. This is the dismissal. My name is not there. Only advocate. You said this was for.
Yes, are you opposing?
I vote.
File replacement. Who you are appearing for? Counterfeit. File the counterfeit. You are for opposite parties, all the opposite parties.
No, 1 and 4.
You have written opposite parties. You have written opposite parties.
That is opposite party 1 and 4. I filed Faklatnama in respect of opposite party number 1 and 4.
Well, already second appeal, already he has filed the one.
There are seven respondents.
7.
One
You,
time.
you are appearing for 1 and
1 and 4.
write down 1 and 4. For opposite parties you have written. Write down. So appears for opposite party number 1 and 4 and 5. Whatever the service. 4 is the appearance.
1, 3, 5, 6. 6B, 6C, 7 refused. Hence return.
refuse.
Only OP2, madam, notice on.
No such address.
No.
Press address for OP2.
Madam, tomorrow I will get the correct for the
So for example, the part number. If you. Lease the matter.
Tomorrow I will get the correct first.
Yes, next.
35.
Please, your lordship. Your lordship disposed of the CRLMC, where I had challenged the proceedings on the ground that when cognizance was taken, the chemical analysis report was not available. And I had cited a fact that matter was pending in the apex court, my lords, in that case relating to Muhammad Arbaz. And your lordship disposed of the CRLMC, saying that final orders will not be passed, the trial concluded until Arbaz is done. Because of that, the trial is at a standstill.
Trial is?
At a standstill. So Arbaz has not yet been concluded. No final judgment has been passed yet.
You are the accused. How does
Okay.
it affect you?
I remain in custody, my lord.
Also, you are in custody, okay. But you move application, bail application. Has your bail application
My
rejected?
bail application has been moved. At that time, my lord, I was not told that there were antecedents. But it was found that they had some antecedents.
So what do you want? The judgment should be pronounced?
No. I want your lordship to direct the trial court to dispose of the trial. To complete.
Without
the trial.
waiting for.
Yes, without.
Because he knows that there is no material, he will be acquitted. What do you say?
Please, I will ଦେଖ କପି ଦିଆ ହେଇଛି ସବୁ। ଶହେ ଥର କପି ଦିଆ ହେଇଛି। ସବୁବେଳେ ଖାଲି କହୁଛନ୍ତି କପି ନୋଟ୍ସ। ଏଇ ଦେଖ ପଢ। ଆପଣଙ୍କ ଲିଷ୍ଟକୁ ଦେଖନ୍ତୁ।
So I'll record and I'll modify that order.
Yes, ma'am.
9 ଏପ୍ରିଲରେ ଗୋଟେ କପି, 3 ଏପ୍ରିଲରେ ଗୋଟେ କପି।
Present petition has been disposed of by a detailed judgment of this court. So you can take they take 8/4/2024. The petitioner has moved an application seeking modification of the same on the ground that this court, while disposing of the main matter, has directed the trial court not to pronounce the final judgment in the trial, awaiting the outcome of
Muhammad Arbaz versus State of
outcome of the outcome of the judgment in
Muhammad Arbaz and others
state of NCT.
versus State of NCT of Delhi.
The main contention of the petitioner before this court was that the charges find without the chemical examination report from part of the case. And so the charges, the case charges is not charged to either. This precise issue is very is pending later revision before the court, before the Hon'Ble report in Muhammad Arbaz. Therefore, this court, while disposing of the petition filed by the petitioner by judgment is full there is a directed that directed the trial court not to pronounce the judgment. Directed the trial court to choose this trial.
No final order. Your lordship said no final order.
Proceed with the trial, but not to pass the final order. Not for this trial. Mr. Pandal and counsel for the petitioner submits that petitioner is in custody. Non-pronounced of since the trial is already been done. But for the judgment of this court, the final judgment has been pronounced. On the pronounced. The petitioner is fate is,
It is
his fate is, his fate is, therefore he seeks, modification of, judgment. So, to the extent that, without prejudice to his, right, in so far as, the contentions raised by him in the present petition, the, trial court may pronounce the, final judgment.
Take up the trial and pronounce.
Take up the trial and pronounce the final judgment. Regarding to the statement made, regarding to the statement of Mr. Bonda, made in the bar, I am inclined to modify the order, modify the, judgment of this court, so, and direct the trial court to proceed with the trial, proceed with the trial as part of the final judgment. Judgment in.
My lords, I have given
Particularly.
in the IA first paragraph, TR case number 83 of 2023 on the file of the landlord, second additional sessions judge. May I crave another indulgence? A copy of this order be forwarded to the trial.
Yes, copy of the trial. The earlier judgment copy might have gone, obviously, so it has to go. Yes.
And urgent copy.
So the notice is issued to the OP number 2, my lord.
36.
Yes.
No such person.
Because what has happened, my lord, in that case, because only word is not reflected, that is, Sravani Priyadarshini Mallo alias Beura, he, after coming to know, she did not accept. For that reason, I have categorically mentioned in paragraph 3 of this petition, and also paid for a press requisite be issued. I have already given the press cause title mentioning that thing, my lord. And she tried to avoid for that reason, my lord.
It is permitted to file the press, of the party and for the public for corporate.
Unutilized copy may be utilized, my lord.
Unutilized.
With your lordship's permission, that name may be, I have already given the cause
You
title.
have to file it because, they are paperless.
Yes, so far the wording is there, for that reason.
Whatever
avoided
it
to
is.
receive. Well, much obliged.
Whatever you want to do.
Much obliged.
Yes.
37.
Withdraw. Yes.
38.
By tomorrow I'll file the requisite.
Sorry?
Requisite,
Not file the requisite, by tomorrow I'll file it.
This person to the order handing 25 requisites have not been filed. See, the interim again same problem. When you take interim order, then I'll vacate it.
Sorry, because it's a.
That's the problem.
Shortened not so that.
Some or the other, it is done like. It looks like a deliberate attempt. That's the problem. Whenever there is a stay, you do that.
By tomorrow.
You pay the cost. Persons to be order dated 13/3/2025. The requisites has not been filed by the petitioner for issuance of notice to opposite party. Since a interim direction has been made by the order dated 13/3/2025, and the petitioner has not filed requisites, therefore the cost of rupees 1,000 of bar to the.
Sorry, cost.
Oh, 500. Cost of rupees 500 we paid by the petitioner, and in 1 week time we plan to file two things after. Subject to paying cost of 500 to the bar.
Entry order.
Entry order.
39.
Notice will issue to opposite party.
postal tracking report showing
Address cannot be located.
Next matter next week, informant already.
Sorry?
Informant appear kochi.
Sorry.
Again. Compromise.
Simply urgent. You bring it. Okay, simply urgent. Despite name, please service of the notice on opposite party number 2 in certificate. That we serve the opposite party. Please the matter. Yes.
What title the name has been wrongly means a Horis instead of horse, my lord.
Hers. Should be.
HARSH, but they written
Acha.
Horis.
The order dated 19/3/2025.
Right.
Hari Singh. Hari Singh.
Hindfoot.
Hers Singh order. Okay, for the okay.
Yeah. Okay, another 4 weeks to surrender.
Acha. So,
The advocate not a village. Name of the advocate. That is not required. That is correct.
who appeared?
My lord. Instead of PK, N Lenka. That is
Today's PK earlier reading in that meeting. Hers कर दो तब action
41.
Modification or order.
41, huh?
Modification.
Yes, what?
Order dated 7/3/2025. Court name may be changed in paragraph 5.
Court name?
CJM assistant session judge can corrected to additional session judge both.
Prayer portion it was written.
In petition you have written that.
My lord, the case was transferred.
CJM additional session judge both.
The case was transferred to additional session.
But in the petition you have written right now. The petition is seeking correction in the order date case 17/3/2025 regarding the name of who? The court of CJM.
CJM assistant.
Vote to
Additional session judge. Additional session judge both.
The case, the HT case number 28/2024, which was pending before the court of CJM assistant session judge both has been transferred to session judge.
Additional session judge.
Accordingly incorrect.
Additional session judge.
Additional session judge both.
Extension. Extension.
42.
May please your lordship, lord. Is a matter Miller relating to Lord elopement and squarely covered by your lordship's judgment recently passed in my case. But however, the notice has gone not returned. Not returned. The
What is this case now?
stage below
We are appealing. Yes.
No, my lordship. I'm appealing for the state.
investigation completed.
Investigation completed.
Yes, my lordship.
Yes.
Completed. Only 363. FIR is registered on 63, only 363.
They are married.
Yes.
Petitioner is married to the opposite party.
Yes, yes, married both are.
Why don't you bring her?
Yes, yes.
That's why
if
my
you-
lordship notice was showing
I-
undelivered
I-
notice.
Huh?
Undelivered showing.
But
Both, joint application.
If you have already married, bring her.
Yes, yes.
Why are you waiting?
No, your lordships, because without lordships.
Yes, I already issued notice.
Notice to the father, informant.
Yes.
Notice has gone to the informant and both the boy and girl filed the application, joint application. Your lordship fix a date so that.
I'll just fix a date. Yes.
3.
Lordships, I appear in this matter, your lordships. Lordships, Mr. Shashwat Acharya is leading me in this matter. He's in some personal difficulty today. So I may pray your lordship may kindly have this matter next week. Am I audible, your lordships?
What is the 3 matters?
Lordships, this is relating to a domestic violence petition, your lordships. Application under Domestic Violence Act, your lordships.
All the 3 matters.
Lordships, all the 3 matters.
Please notice.
Lordships, may kindly have it next week. Mr. Acharya is leading me in this matter. He's in some personal difficulty.
Already issued notice. Matrimonial dispute, yes.
Lordships, we need to press for some interim relief. Your Lordships,
I
may
have issued notice, let us see.
Lordships may
Yes.
kindly adjourn this. Your Lordships, simply
If,
adjourn.
if at all I'll adjourn it beyond vacation. It will go to July. Because it's better, I have listed it, means you have to argue. Therefore, I'm issuing notice, better for you.
Lordships, in that case, your Lordships may kindly pass over. Obliged, Lordships.
44.
May please, your lordship. Well, this is this matter, my lord, where this accused persons have been implicated on the basis of only 161 statement of the co-accused persons. No seizure from them. This is, and last occasion, they had taken time to see, take instruction as far as to whether any property has been seized from them. My stand is that, my contention is that, except confessional statement. And if, my lord, the lower court record is there, I don't know whether, my lord, I have the certified copy. This is also clearly mentioned by the court below. That
Yes,
except 161 statement, that is nothing.
Yes, Mr. Jana.
Well, this is a case that initially a truck was, with loaded some
Aluminum ingot.
Aluminium mallet was moved from towards the Calcutta. These some persons have taken away that vehicle, stolen that vehicle. And the owner thought that this perhaps that driver and helper has stolen and sell somewhere. For that, he has filed a complaint. During investigation, it came to know that these several persons have kidnapped that two persons and sold these aluminiums to this petitioner and another man. And this petitioner was absconded. For that reason, my lord, on the basis of where that vehicle was also seized, where that aluminium has been given, so it could not be interrogated. Subsequently, he has surrendered, my lord. So police has no scope to investigate the seizure of that.
No.
My humble submission, Lord, that is the
Investigation is still going on.
My lord,
investigation.
investigation.
Charge sheet has been filed long back. Charge sheet has been filed long back.
Are there, statutory period is there, my lord. Yes. For that reason,
Charge sheet has been filed.
Has been filed. And so far seizure is, my lord, and senior saying, sister is saying that seizure, admittedly there is no seizure from this petitioner because they were not arrested from the spot. And they have not stated where they have kept that aluminum.
What is the material then?
Then, my lord, the statement they have stated.
Who has? Who accused person?
My lord, but this is a case, my lord, 396, and who other will say, my lord? And they have specifically at the time for that reason, my lord.
How will you secure conviction?
For that reason, my lord, section 30 of the Evidence Act is there. If evidence will not come, my lord, then at the stage of, my lord, affair questioning, this is a case. He has come at the stage of.
How will you secure conviction?
My lord, your lordship may kindly see. Even section
On the
30.
basis of
For a moment, your lordship may kindly see section 30 of that.
Evidence check.
Well, one aspect which I think he got it wrong is his Mantosh Sharma, he was arrested and he was released on bail. Ravi Sharma was released on anticipatory bail on the basis of which he was granted bail by the learned court below. So because they are only liable for receiver of stolen property. No, receiver of stolen, that is the charge sheet is against them is 412. Receiver of stolen property.
Consideration of proved confession affecting person making it and others jointly under trial for same offense, because this petitioner and others has been facing trial in one case, So at the stage of cognizance, the magistrate will only see whether prima facie case is made out or not. Affair, at the stage of affair, he has come.
Trial already
commenced.
Trial or not commenced? Trial commenced.
Yes, section 30, yes.
No, I am conscious of that, my lord. But your lordship may see, it will be sheer abuse of process of law, my lord. Because
but see, if
when
section 30 is taken into consideration, the only conclusion is you have to face the trial.
But my lord, my only submission is that as far as these persons are concerned, the only offense they are liable is 412.
I am not on that.
So
I am not on that.
no, let them sow a single a piece of paper or out of evidence that any incriminating material has been seized from them, any phone call, any details.
He is agreeing to that.
So there is nothing, only on the basis of a co-accused statement,
But
my lord, all
nothing is
these.
clear now. These confessions,
I would like
may
to-
not be 27 confessions.
They're not,
the 30
this
confessions.
very weak piece of evidence, my lord.
Maybe.
Very weak piece of
It will be
evidence.
excluded, but at this stage, I can't.
No, my lord, let it.
At the time of charge, let him.
No, my lord, let me place your lordship. I would like to address your lordship on this. Your lordship may put it to 1 week, first week of May. I'll address your lordship on
Get
this.
out of 30.
Yes, I'll get out of 30 and I want to place some, because I'm sure they have not placed the LCR or the record has not been there before your lordship. I would like to point out from there how the co-accused persons are situated differently from this.
On the request of
45.
55 minor,
My lord.
I'm praying for fast.
Well, at 44 interim order ta thila. First week of,
Let it come next week.
which one?
45.
45. You have opposite party. On the request of opposite party, release the matter.
Interim order.
46.
He's asking for passover.
My senior is in flex in another court, my lord.
Let it sorted though.
46.
It's 6. Who is that 46? That then 46?
Yes,
Yes.
Non-civil petition.
Page 57. What are you? Your lordship, may kindly turn to page 37.
Yes. Yes.
Here your lordship, may kindly see on the left hand the date of the bill.
37.
Number 5, page 37.
Yes.
The date is 5/12/17 and invoice number is 16. 606
Yes.
on the right side.
Yeah.
And if your lordship will kindly see page 39,
Yes.
serial number is, invoice number is 7. Date is 10/2/2017.
Yes.
So this itself shows he has manipulated the bills. 10/2/17 7 number invoice habo. ଆଉ 5/12/17 6 number invoice କେମିତି ହବ? And there is the GST number also. From the very inception.
GST number is same 21 PA MZPP.
And he has from the very inception, he had created the bills subsequently with a intention to cheat the present petitioner. And actually 1/4/2017, GST was introduced. And at the relevant time, there was no GST. So he could not have put in the GST number also. So this has been manipulated subsequently to cheat the person.
When GST introduced?
Here GST number he has put in. 1/7/2017 GST came.
1/7.
Yes.
May I just.
And it is 5/12 only.
May I just clarify one thing?
5/12.
10/2/2017 is
Which invoice?
39.
Which invoice you are talking?
7. GST number
7.
page 39.
Invoice number 7.
Yes. He has put in GST number. The whole purpose I am showing these mirrors. These documents have been created subsequently with a purpose to cheat me. That is the entire.
Kindly, Lordship, I mean, Lord Senior has shown just two bills. There are other bills. Lordship, first come to 512.
Please come to page
512.
39. How will we get out?
I'm just coming here. My Lordship, 512. That is bill number 6. Then your Lordship, 1412. That is invoice number 8. That is at page 38. Then the what is been shown to your Lordship just 10-2. Well, it is imputed as 10-2. It is 7. The next one is 1712. It is 9. Then it is 2012. It is 10. May I just why I am showing it? Then it is 2512. It is 11. So merely a 10-12 break again is missing there. And this is otherwise the bills are in sequence.
You say it is 12. 10-12.
It is. Therefore, the GST number and everything. And what is the case, my lord?
No.
I have taken money, given them the Kaju, everything. And they themselves assert that's a breach of contract. And they have stuck in, and the court below says there is a civil dispute. You can go to the civil court. That's the case only. And now my lord and senior is being instructed to show this.
No, what
From
the white and black and white.
No, what it says that, see, if you ignore the 7, invoice number 7, all the invoices are in the sequence. And even invoices number 7, one is missing there.
Your Lordship, kindly see. No, in every date he has given
36.
This manipulation is slippage.
No,
Just a minute, I'm saying. It is every bill your Lordship may see. After each date he gives a How can he just say here it is a mistake? The man who cheats, he knows how to cheat. And he is a person who has been cheated huge amounts. Yes.
This is we have shown in our GST. We have taken everything. This is the tax invoice. Yes, we have shown it in GST, and this is being.
Yes, who is appearing for this case?
GST is B2B. B2B.
No.
No. Or GST order ta dekhun to again.
It's a complete case.
B2B.
Is it a complete?
Yes, my lord. The complaint case, cognizance was taken. I have challenged that.
What is the amount involved?
Amount involved.
There is no
19 lakhs about 19 lakhs.
No, my lord. As per my, there absolutely no. The money entirely has been paid.
You have paid.
Yes, apart from that, what else you find?
Millers?
What else? Anything else?
Yes, Millers.
Wonderful.
Your Lordship may kindly see the GST.
Yes.
Page 31.
31.
Annexure 2, page 31.
Yes.
It is the department's order.
Seven 10/2020.
Miller?
7/10/2020.
7/10/2020. He will explain the taxation matter, he knows better.
The verification that has been issued by the police that whether he has been sold the goods to the person concerned, I mean the appellant. Here, it has been referred that there is no B2B. B2B means once a registered is sold to another registered, it is a B2B. If it is B2C, then it's a non-registered dealer. So he has verified the return and find out that he has not sold the goods under the B2B. Because he has to take the ITC on this respective subsequent sale. Therefore, Lord, here is a clear case that has manipulated.
It is on verification of
by the department.
December 17, January 18, and February 18.
Yes, police are issued to verify.
No B2B.
Yes.
Yes. There is a B2B sale has not been reflected in my return. Your Lordship, the clarification is also on 18/1/2021.
Which page?
At page 33.
30?
The transaction has been shown, 33 and 34. The transaction has been shown in my GSTR1, reflecting it to B2C, business to casual dealer. So, yes, correct. That by wrongly, this is
everything is wrong.
I'm just
everything is wrong.
My lord, this is a new taxing law came into statute in 2017. 2017, this was occurring. My has reflected it at B2C sale. The same person remains.
Should have been B2B.
B2B. That's correct. So this can be corrected and they can get the input. That's not in dispute here.
No,
the question here is that do I commit a fraud or cheated them? I have sold them I've given the invoice, I've reflected the invoice in my GSTR.
See, two things they have apparently shown.
Yes.
One is the GST B2B.
B2B, that can be corrected, my lord.
B2C. Everything can be corrected.
No, but
Whether
this-
the intention has to be seen.
That is the only thing.
Whether you have indulged in all these things. Or that
Yes,
is
my lord,
okay.
that's the case.
It can be corrected. No.
My lord,
everything.
if I anything.
You pay the money, it will be corrected.
And I am not, if anything, my lord, they are the case that I have never sold them. Now
Brahma
they are
Pisai-
showing.
See, Brahma Pisai, they made out a case
So, my lord, they,
that you have manipulated certain documents.
No, I have
Whether it is 2/10/2014 or 10/12/2014, it looks, it is apparently 10/2.
a
Then
dot
two,
has been.
one is missing. I don't know whether how it is missing, who has missed it. All these things, evidence is to be laid. You have to need evidence. The person who has filled
No,
up
no,
and
no.
asking the question whether it is 2 or 12. All these things I can't go.
My lord,
into.
these are, but exactly, my lord, that's what I'm saying, that the revisional court has come to conclusion, these are civil dispute and they can better go to civil court. And accordingly, quash and they have come forward that I should.
Let us see the order now.
Yes, my lord.
Before lots of.
That's the case, my lord, not the.
Another.
I am not saying that it is to.
Stop. Before going to this, the order, kindly see page 33 for a moment. This department has stated now, to the yes, kindly see page 33. Lord, just give a clarification whether there is transaction is made between the two parties or not.
Yes.
In course of inquiry and data available at this end, it is revealed that Ms. So-and-so has not shown any transaction detail against a so-and-so industry in GS1 concerned tax period so-and-so. It is here to be mentioned that form GS1 detailed afterwards supply declared by the supplier, but on verification GS1 filed by supplier so-and-so is found that he has not shown the supplier so-and-so in category, which is required to be shown in clause 4 B2B transaction.
It's a taxing
He
situation.
says that B2B is not.
We cannot now.
Next paragraph.
Yeah,
But during the course of inquiry, Mr. Sri stated that GSTR 1 has reflected the entire sale in column 7 of GSTR 1, which is B2C sale,
B2C.
which is against Canduli. So I have sold them, shown it in the GST portal, given them invoice, everything has done. And merely because it's a transaction reflected wrongly in the doesn't make a criminality.
Let me complete. So let him.
And then
I will
that-
explain that. But during the course of Sriram Kaju stated that instead of GST, he has reflected the entire GST 1 B2C sale against so-and-so industry. At present, after gap of many months.
But what he says is not a case that is complete concealment.
No, that is the intention to
He
cheat
says
the
that
person.
in place of B2B transaction, it's wrongly shown
He
B2C.
cannot.
Everything shall be wrong, my lord. My lord, I'm only saying, bill will be wrong. Documents showing GST will be wrong. So department findings will be wrong.
Let's see how the trial court,
That is the only
revisional
thing.
court deals with it.
Yes.
Let us see.
That.
Revisional court, how it deals. Yeah, come to that.
All of that. 91 is the order, my lord.
90?
91. Place it, my lord.
Yes. Yes.
The criminal revision is preferred in terms of section
No, no, when
390.
you come to the relevant part,
Yes, my lord.
91 to 106, you will keep on reading over. Tell me the relevant part.
Yes.
How this aspect is dealt with. It is very detailed judgment.
Internal case 8 is definitely. 8 onward, internal case 8 onward is the.
Lordship, see, it starts, may I please note the internal page 3, page 95.
Running page 95.
Running page 95, internal page 3. The complaint file protect petition to the final report submitted by IO in the Rani lower court. The SDM Puri recorded the initial statement of the complaint under section 200 CRPC and statement and other witness CRPC, after being satisfied there exists a prima facie case to cognize offense under section 419, 420 and 420 CRPC and issued process against the petitioner. Before agreed with the impugning order, the cognizance being agreed, the present petitioner preferred this revision challenging correctness, legality and priority of the finding on the impugning order as follows. So now your lordship keep it on going on, then your lordship see we are dealing with the all these judgments, and lastly
have you initiated any civil proceeding?
Not yet. Lord, I challenge this court has issued notice. And his finding, Lord, that is a civil dispute, it cannot be permission order is not last page 13. In the result of under so file evidence allowed a contest, the order cognizant dated passed by agent so and so is hereby set aside. So now the question is whether the intent of cheat is here or not. That has to be a lordship has to kindly see. If it is cheat,
show me this aspect where the court deals with
that. Yes. Take as a court sheet.
Yes.
Blood page 100.
Yes.
Internal page 8. But there is the judgment is referred and starting point in which their lordship have held the tendency of convert priority civil dispute into criminal cases. In effect, to settle the civil dispute and claim which do not involve any criminal offense by applying the pressure to a criminal prosecution should deprecated and discouraged. With touchstone of the above established principle, the instant case being where there are prima facie case to constitute the offense under 419, 420 and 420 CS as IPC. Again, the petitioner, whether the process issued against the petitioner justified. There is an oral agreement between petitioner and the OP supply 36 ton of cashew nuts by the petitioner at the rate of so-and-so kg in the December with a condition to advance payment. Accordingly, the OP had transferred 37 lakhs of rupees, 70 lakhs to the petitioner and tune has been, and the turn has received 14 numbers of cashew nuts from the petitioner. It is alleged that OP has supplied the cashew nut to the tune of so-and-so and failed to supply raised 32 notes of cashew nuts constituting rupees so-and-so. It is further alleged that 7/7/2008 about 11 AM, the OP approached the petitioner in this office for refund of the raised amount or to settle the matter, but the turn petitioner abused him in discouraging language and threatened him to discuss your language and threatened him not to come.
Now you told me 202.
202.
202. Have
Yes,
you in 202? Have you said about this invoice number 7 and the GST?
Yes.
Have you said that?
No. Yes, ma'am.
Show me. Either in 202 or you are in complaint.
Yes,
Have you
ma'am.
said those things?
No. Yes, ma'am.
If that is not form part of the charge sheet, where is the question of taking those things into consideration to upset a judgment which is already passed in his favor? So in complaint.
Yes.
Where have you said that? That the invoice number 7 is a false document and the GST number is also false. Where have you said that? Show me the complaint.
Yes, ma'am.
Very
In fact, they have admitted it's a breach of contract. Specifically in the petition, it's a breach of contract. Now in their affidavit, they're saying that is wrongly referred. Para 5, your lordship can see it.
In the complaint, you have not said that.
In complaint, blood.
You have not said that. 202 statements to show me.
202 statement.
202 initial statement. Annexure 5.
Yes.
Come to annexure 5. Where have you said?
Yes, ma'am.
Then
Page 84.
see, neither in the complaint nor in 202, you have brought on record these documents to show that he has forged it.
Yes.
Then today you are trying to justify.
No, it
After not revision,
no, it is,
got allowed.
it is not just now. It is it is in between the.
You show me in the complaint, have you filed those documents? It is your complaint.
Correct, correct.
You want to make out a case under 420 on all. Have you relied upon those documents? If you have not relied. What can be done?
These documents we have collected from the police lot. After they have.
Have you placed it on record in your either in your complaint or 202? Answer it. If you have not done, then I will not interfere because the revisional court has rightly said that.
But all the same, Lord, regional court absolutely receives correct so far as this issue is concerned.
You can't. You can't.
No, there is another issue.
I read it. Your complaint as well as.
Yes, sir, that I understand. But
see, the cognizance is taken on the basis of your complaint.
Yes.
As well as 202 initial statement.
Yes.
It was both the things you have placed on the record. In both the things what you are saying today, those things are not part of the record.
It is.
So therefore, the revisional court,
it is 153.
The trial court very mechanically has taken cognizance. Simply taken. And the revisional court,
yes,
by a very detailed order,
yes,
page 91 to 106.
Correct.
He has dealt with everything and said that by reading the complaint as well as 202 statement, no case is made out. No case is made out. What can you do? Today you are challenging that order by relying upon some document that cannot be considered.
That document is with the police inquiry report that has been supplied by the department to the police, not to us. That document which we are relied upon.
Complaint, where have you said that?
No, that's
then you want to make out a new case now.
Your Lordship, see page 70. That police has given all from the statement.
I'm only on the cognizance. I have to see the complaint and the 202. I will not see anything.
Police report.
I will not see anything.
The intention has to be seen because
intention where from? Intention has to be seen from the record, not the intention.
That is right.
I see from the,
that is true, but
from the record you show me the intention. On the record, if you can show me the intention, very well. I will interfere. I'll pass the order you show me.
Tomorrow. Kindly keep it tomorrow. I can.
1, 2, 3, 4, 5, 6, 7, 8. 8 hearings.
Okay, tomorrow. First item. First item.
I'll not give more than.
No. Only that issue.
Because I have a whole substantial 20 minutes.
Police report at what stage it has come. In the record, I don't know.
I may pardon, my lord.
5 minutes, as it is, I spend so much of time. Another 5 minutes for their solution.
I am filing the affidavit. Good.
Hello? I'll take it about 2 o'clock. You need not come. You come. You need not come and do it. You are considering.
Yes, but I am filing the affidavit.
It's very good that you keep on fighting with your husband. Leave the parents. I'll pass it. Parents only.
Parents, yes.
He doesn't want. Parents help. 72 years.
No, now it's 74, I guess I have written. 74.
Or 22, 72 thing.
Maybe 74, my lord.
Good that you are only.
I may be pardoned, my lord.
I'll do it.
Item
2 o'clock you come, I'll do it. Huh?
Item 49 minutes. I may be pardoned.
Yes.
I may pardon, my lord. One CRLMC 3731 of 2012. It is not on the board, my lord. It was listed on 10/3/2025 along with another CRLMC number 3790 of 2012, my lord. On the prayer of the State Council, matter was adjourned for 2 weeks, and your lordship has passed interim order to continue. That interim order is reflected in one CRLMC. Then other CRLMC interim order has not been reflected. Now, my lord, the police has reached to the residence of the house of the petitioner, who is an 89-year-old man, to arrest him, my lord.
You send ED to them. ED is under your.
So I pray, my lord, let it be taken up at 2 p.m., my lord. Only for limited purpose, so interim order to continue, your lord.
What police is doing now?
Police has gone to arrest that man, my lord, at Agra, my lord. They are sitting at his residence, my lord. On the prayer of the State Council, my lord, matter was adjourned. One Mr. Bora, additional SP, sitting at the house residence of a 89-year-old man to arrest him, my lord.
My lord, 10/3/2025, 2 weeks time was allowed, my lord. Can be taken up tomorrow, losses because the year-old.
No, you have taken time here and you are sending, your police is going and arresting someone.
And 89-year-old man, my lord, is bedridden. They say that we will arrest you.
Which police is it?
Crime branch, my lord, one Mr. Bora, additional SP has gone there.
Tell your crime branch people not to do all this.
Possibly keep it listed.
But if he is arrested today, what will happen?
Whereas, my lord, interim order was continuing in second matter, my lord, no order has been mentioned, but they are saying it has been vacated, we will arrest you.
Just check it up. Huh? In the afternoon, just check it up and tell me.
Or your lordship may call it tomorrow, my lord.
Better, man.
49 टा my lord. Yesterday pila Oklahoma passing by. The form and
49. I'll take it up. I'll take it up.
Mediation has gone, but senior is saying that it's a quash.
mediation.
Because wife,
Fail, mediation fail.
yes, agreement with the wife, husband files the criminal, one CC case.
My submission, the 54. The other day I said the order is indefensible.
Your submission is to for adjournment, both joint request.
No.
It can be quashed.
If your lordship, without recording my concession, it can be.
Then I'll take it up.
Purely civil dispute.
Civil dispute.
For 45, Lord adjourn the matter is a matrimonial issue subject to my friend is appearing. It may be referred to mediation. That will be
45.
Aye. It was urgent.
May pardon your lordship.
Urgent.
High Court mediation. Sir.
Again.
High Court. Convenient request.
Obliged.
May pardon your lordship. So lordship 53 item. Where affirmative petitioner your lordship. Mr. Panda has an instruction to appear your lordship. The list has been missed your lordship. So maybe adjourn.
57.
53.
53 on the request of.
My lord, in that case,
Yes, yes.
6,000 maintenance was granted. In 127, it has been enhanced to 10,000. This honorable court granted the order of stay. The wife and son is not getting 1 rupee. Maybe Monday it may be taken. 6,000 originally awarded 125. Enhanced to 10,000. This honorable court granted stay. They are not receiving 1 rupee.
No, there is a opposition. You come.
Item
Before after lunch one.
Yes. Thank you. I'll take it up. Yes.
Item 50, my lord, adjourned for 1 week after. Today is the mediation.
50. Mediation.
Today is mediation.
50 what?
50.
50.
Final.
I'll take it up.
Appearance of both the parties. The principal is in VC and the reader.
Petitioner is present here, madam.
Petitioner is there.
Yes.
74.
74.
74, na?
It was 74.
Yes.
Offense under section 506, madam.
Yes. What are the allegations, by the way?
Allegation that you on telephone message, somebody has telephone. He is saying that you have used that telephone.
He has telephone.
No. He has not.
Now
used
you
it.
have settled the dispute, na?
No. Your lordship is called both of them to, if it is settled for that reason.
Yes.
Telephone, who is the telephone was used?
Who is the petitioner? He is the professor.
No. He is the reader in Odia.
He is the reader.
Yes, he is the
And
principal.
who is the
Informant is the principal of the
In the same college?
Same. No, different college.
Different college.
Previously, the reader was in that college and he has been
First of the
transferred.
case, my lord, the telephone which was used, that was not never seized and it
Then
was
it,
not belong to
then
the
it,
present
then it will be decided on merit. Can it be decided in this stage?
What did he say by calling?
Let them say what.
What did he say? Contact the person.
Page 15 of FR is at page 15. If my non senior is wanted to do it on merit, then I have to.
No, what is the fact I am submitting? I am not
No,
saying.
it is not necessary to.
Yes.
Both are present. If that will be settled, then it is settled. No, otherwise.
He is appearing.
Through VC.
Jatin Kumar.
Jatin Kumar Mahakur.
Jatin Kumar Mahakur. Can you hear me? Yes, what do you want to say?
Sir, se phone re dhamak deythile sir. Au purbaru sabale misbehave karanti. Phone re कहले brain logei ki kamo karantu. Au tanko birodhare झटका जारी हेतिला सब कलेक्टर
brain logei kamo kariya katha. What is wrong in it?
ना धमकेबाटा sir se junior mochu.
No, you are a principal of a college. Try to be little tolerant. All these things you are not supposed to come to the court. You are supposed to do something good.
Sir.
Why don't you settle the dispute? I will suggest you to settle the dispute.
Sir, se sub collector sir kortile tanko against notka jari. Mate se कहउछन se notka jari potka.
Parties are there?
Yes. No settlement.
Okay. Oh, it's a covered matter, he says.
Your Lordship, I turn to the second case, my lords.
Yes.
The second case is criminal division of 7. I'm audible to my lords. 713 of 2024, my lords.
Yes.
Lordship, may kindly peruse the prayer, my lords.
Yes.
Prayer is at page 16, my lords. Petition 6 for an orders, my lord, for setting aside an input order, annexure 6, my lords. Annexure 6 is at page 47, my lords.
Yes.
Now, my lord, the lordship turn to page 48, my lord. The first line of the input order says that against an order rejecting its application, he has prepared this revision, my lords. Now, lordship, we can turn to the next page, my lord. Page 49, my lords. Lordship, you can see the last line. Did lordship get that line, my lord? A verification of the case record, it reveals that after framing of charge on 15/1/2018, the prayer is in this revision is for quashment of the orders by which the discharge application rejected, my lords. But in the meantime, my lord, last two line, I hope your lordship got it, my lord, page 49. A verification of the case record reveals that the framing of charge on 15/1/2018 against the accused person, 14, your lordship can indicate, see that 14 the person have been examined, my lords. Now, you, my lords, the fag end of the trial, my lord. Lordship, expeditive matters, my lords. Relative range, whatever he is raising here, my lord, before the trial court, my lords. And my lords, and my lords.
We have filed.
Listen. And my lords, I am fortified with another two judgment of Supreme Courts. One Supreme Court said, once the charges are framed, the accused cannot be discharged. Discharge post-framing of charge is not recognized in the implementation of the format. The accused may either be acquitted or convicted, but he cannot be discharged. So there are two Supreme Court judgment, 89 Supreme Court 1715, lords.
This is regarding the second matter. What about the other two?
Lordship, may dispose this one, lords. I will assist your lords. Same standing. Same standing. My lord, when they at the far end of the trial, my lords, application have been filed, my lord, with the Southern courts for quashment of the orders by which the discharge application is rejected, my lords.
After charges.
Yes, my lord. This particular, whatever the your lordship may grant them the leave, my lord, to raise any points. These are all, my lords, different.
In all the three cases, the same situation.
Same thing, yes. My lord, I'll just say one after another, my lord. But so for this case, this should go to the trial court, but to decide all the issues raised, leave may be granted to my lord to raise all these, because the defense plea has to be proved by addition goes and evidence to that effect.
Okay, what about the first matter?
That, my lords, this is 14 witness and examined. The first matter is 712, my lords. I think lords, we are holding that particular brief, my lord. Your Lordship can turn to the page exactly at page 48, my lords.
48, yes.
The second paragraph one, a verification of the case record, it reveals that our framing of charge on 11/5/2018, my lords. Against the accused person, 6 witness have been examined. And my lords, these input orders passed 6 months back, my lords. 6 months back, my lord, the situation was that 6 witness in this case, 14 is that case, my lord, the trial commences, my lord.
What about the third one?
So, my lord, sir,
Third one. Yes.
third case, my lord, let it come tomorrow. So, for these 2 cases to go.
The third case is there, yes.
Yes, sir.
You come to page 50.
730.
One minute. Then my lords, we turn to page 52, my lords. Page
54, come to 54.
54. That, my lords, I'm expecting, my lords, I'll get instruction this line because the order was passed in the month of November. That's 6 months back, my lords. Well, I'll get that instruction. So, but these 2 matters, my lords, it's not maintainable, my
Yes,
lords.
sir. The first 2 matters. The third matter can be allowed.
No, after the filming of the charges, the petitioner filed a petition. Thereafter, order has been, the petition has
Show me
approved.
the order which, according to you, are covered.
So,
Annexure 7.
So, but that please,
That is a cognizance order was challenged and that was passed.
Their cognizance order.
Yes.
Here, charge has been framed. Your charge has been framed.
After
Everything is
framing
going
of the
on.
charge, I have-
At that stage, you are coming and questioning the discharge.
After framing the charge, I have filed discharge petition.
That can't be.
Yeah,
That's the law.
That's the law.
How to go about it? Third matter, I'll allow.
Lords,
First
grant him
matter, I
leave not to raise all those points, whatever raising is, my lords. And your lord may expedite the trial also, my lords, no problem.
So I have to let it to Monday, my lord.
Monday thing will not improve, sir.
No, they keep it.
Urgent. Third matter, I'll allow.
No, so there also, I have got another submission on the point of subsilent, my lords. The judgment he relies, my lord.
The third matter is challenged, there is no evidence recorded there.
No. He is relying a particular judgment, my lords. That judgment has been passed in subsilent, my lords. It's not authoritative judgment, my lord, doesn't have the precedence valid to be followed. There is in, my lords, a particular plea of a question law which I raised because that it could not be considered, it could not recorded in one line, my lords.
Show me that judgment.
My lord, lordship may.
Annexure 7.
Yes, Annexure 7. You are see.
Annexure 7, my lord, that is page.
Yes.
Page 50. Page 50.
Which part? It's a very detailed judgment.
730. Lords, we turn to page 58, my lord, the judgment on which he relies, my lords.
Yes.
50, lordship got it, 58, my lords?
Yes.
Your lordship in the paragraph 2, my lord, 1 minute.
Para 2.
Para 2, my lord, does provisions, my lord, 420, 468, 479, 120B.
Yes.
My submission on the 120B, my lord, petitioner in this case, my lord, is a non-public servant, my lord. He was the person to supply 2 non-existing funds, my lords. And my lord, he was working in tandem with the tented public servants, my lord. Now, lords, we turn to lords, we turn to page 62 of lordship reports.
Yes.
Para 8, my lords.
Yes.
Mr. So-and-so, Lord and Standing Council of Vigilance submitted that it is too premature a stage to raise all these challenges to the order issuance of process against the petition. And the exact role of petitioner can only be found in my lord. My lord, I raise specifically, my lord, the pleas pertaining to 125B, that he was working in hand in gloves with the public servants, my lords. Public servants, they trace out, my lords, in a fictitious farms, my lord, where the subsidized coal is to be supplied, my lords. And this fellow was in charge by non-public servants, my lord. So, my lord, I need not place, my lordship, that just the case of Nalama judgment of the Supreme Court held, my lord. Once, my lords, a 125 bill was the conspiracy in secrecy, my lords, that cannot be proved by direct evidence. That too, my lords, once the public servants comes, he comes within the sweep of the non-public servants. These particular points are raised, and my lordship.
But it was at the very threshold, it was challenged.
Yes, and my lords, I'm placing another judgment of this honorable court, my lord.
But you have not challenged this order. This has become final.
What?
This order has become final, this judgment.
No,
Lordship,
my lord, that judgment is
What is the role of?
No, listen. My lordship,
See, now, technically you are.
Yeah, my lord, that particular, my lords, I argue that matters for half an hour. One line there, and that has been cleaned up. My lords, what I suggest, my lord, it is, your lordship correct, it has achieved finality so far that case is concerned, that factor circumstance involved in that case is concerned, doesn't have the precedence value. Lords may put me a question why I'm lost. My lord, I'm placing another judgment of this on court's lords reported in AR 2000 Supreme Court 103, my lord. Here the concept of subsilent operation service, my lord. And my lord, here as the basic assumption on Messrs. Cellular distributor is found to be, not in the case another, is found to be non-existence. In our view, the said decision of Mrs. Sarda distribution was arrived at subsilento, and according to the said decision is not authority of the view of expressed by us in this connection. Reference will be made to the decision of the chapter 5, section 27, subsection 6 of the heading of precedence of subsilento and not fully good. Your lordship, I have my lord, lordship appreciate to service this particular concept, my lords.
So then on all the three cases, you tell me how many witnesses are there. Accordingly, I'll fix the time.
Yes, my lords.
I'll put it on, let it be on 23rd, 24th.
The case from Contractor, my lord, tomorrow also I can bring.
Tomorrow.
Take it. Lordship,
Let it be on 23rd.
Yes, my lord.
Well, lordship, main question is, what is the role of the present petition? It was selected by.
Maybe you are correct.
That's a defense.
But today the problem is charge has been framed.
Yes.
Evidence is going on. At this stage, you are challenging your application which was rejected seeking discharge. How can I discharge you?
Yes, that is the fact.
How can I discharge?
Because after the future, we have filed a petition.
Either you will be acquitted or convicted.
The other case which you are relying upon, that was the case where the cognizance.
Still some issue, my lord.
But
Whole
maybe
affairs have been launched on self-image.
they have come.
That's a good
And
judgment in that case.
I'll expedite the trial.
Yes.
I'll expedite the trial so that you may be acquitted. Rely upon this judgment. The judgment will not, see, they have not challenged this judgment.
Because they just achieve its finality.
It is open for you to rely upon this.
Elaborate, it is clarified that the role of the present petition.
You will be acquitted. So therefore, the best thing is
Get the leave.
Yes. 23rd. Yes. 23rd.
Item 3.
3. Passport matters. Yes. 3. Anybody there?
Item 3.
None appears for the petitioner, even on the control. These in the interest of justice, July.
16.
Look, there are two matters before your lordship. The petitioner before your lordship is an ex-army personnel. He was owning a mill. That mill caters to the demands of the farmers in the locality. He was in duty. When he was in duty, he deployed certain persons to look after the mill. After coming back from his...
What mill?
It's a rice mill. Rice mill. After coming back from the service, when he took over position of the mills, the persons who were managing the affairs started filing affairs against him one after another. Two similar affairs on same verbatim ditto has been filed against the present petitioner. But that has been deprecated by the Honorable Apex Court in the judgments. Your lordship
In your case?
Yes, no. My case is well.
Let us see the allegation first of all.
Yes, your lordship may kindly see allegations. Your lordship may kindly see.
There are two cases.
Two cases, two affairs.
Both the petitions are filed for watching up both
the affairs. Your lordship may
what is
kindly
the stage now?
FIR now police is running after me. That I'll arrest you.
What are the allegations?
Yes, your lordship may kindly see 296, 79, 351, 2, 351.
No, allegations.
Allegations, your lordship may kindly see. That is in page 10.
What did you say? Yes, read the relevant part.
Please stay in your lordship.
Yes.
while the present informant going to
May I read
drink
my-
water from the
ନିବେଦନର ଅଭିପ୍ରାୟ ଏହି କି ଯେ ମୁଁ ଏତଲା
The relevant part you read, don't read A, B,
three
C.
lines, Lordship, from the top of the three lines. Lordship.
What is the relevant allegation?
That is very-
Wait, I'll read it.
Yes, Lordship. There. ମୋର ପରିବାର ଲୋକମାନଙ୍କୁ ବାଟଘାଟରେ ଚଲାଇ ଦେଉନାହିଁ ଏହି ସମ୍ପର୍କରେ ମୋର ସ୍ୱାମୀ ଓ ଶ୍ୱଶୁର କହିଲା ପରେ ବି ତାର କଥାକୁ allegation is Lordship, though is a very heinous Lordship. That's kind of activity of the present petition Lordship.
Where is the, what is the incident?
Incident, Your Lordship, while the present informant is drinking water of the present petitioner is used in slang, in slang
Wait,
manner,
wait,
or in
wait, wait.
unhuman manner, Lordship. That is mentioned in three lines, Lordship, from the top of the affair.
Hostel भाषा गाली झाला.
No, Lordship, another slang language in use I am not able to read in
No,
before the.
that's what the 12/1/2024 ରେ ମତେ ଅଶ୍ଳୀଳ ଭାଷାରେ ଗାଳି ଦର୍ଶାଅ.
No, Lordship, first, second, third, fifth line, Lordship. Fifth line. Fifth line.
What is the second affair?
Second affair. Here is the date of occurrence, Lordship, can I glance from the frame, page 9, Your Lordship.
What is the allegation?
18/2024, Your Lordship, that is Lordship, page 9, Your Lordship, 8, page 8.
Item number 1436.
In the same first item, the two FIRs here.
Yes, 1432 is the first FIR. 1436 is the second FIR.
See, the allegations are very, very minor allegations.
But
One issue notice, let us see, it can be settled. Yes, issue notice. Let me know down. In both the matters.
My lord, I only pray that no coercive action by the police.
So, have you approached the court for
I have filed a miscase, man. I have filed in
438, have you filed?
No, I have not.
See, all are bailable offences.
My lord, yes, but police is saying that I'll arrest you. You come to me or I'll arrest you. This is my problem. I'm an ex-army personnel, man.
The bailable offence, who will arrest you in the bailable offences act?
That is the problem. That is the problem.
Where have you stayed in the IA?
My lord, I have stayed. Your lordship will see at paragraph 3 that even the offences in the FIR are bailable entries, the local police officer are raiding the house of the present petitioner each and every day and harassing the petitioner and his family members, threatening that present petitioner be forward him to the judicial custody by adding higher offences. I have specifically avoided in my miscase.
I can't prevent him if higher offences is made out.
Yes, but no coercive action because unless, my lord, I am given an interim protection, your lordship.
What do you say? See, bailable offences you harass.
That's right, I'm not able to, but
multiple FIRs are
See, problem. See, today problem is he can't file an anticipated bail because bailable offences. What will he do?
when police can 41 can Lordship analyze the petition on bail, Lordship.
You do it 41.
Yes, submit your Lordship. And it's 2 guidance.
I shall I record?
Since
Since it is bailable offences, it is expected that 41 notice.
Investigation is going on, Lordship, that part I have not.
See, what is the remedy for a citizen? You tell me.
I am not
If
disputing,
bailable
Lordship,
offences are there and police is harassing someone, what is the remedy? Because 438 he can't file.
Your Lordship, the present is having 10 criminal antecedents, that is annexed to your Lordship. Page
You
12.
bring it on affidavit that I have
It's given a take 12, 10 antecedents, Lordship.
What are the offences?
That's Lordship, maximum offense is 341, 294, 506, 34 IPC, 447, 307 is also there.
I understood. Right. In IL 975. Since the petitioner has been implicated in the FIR number so for alleged offense so and then counsel for the petitioners in para 3 of the application very categorically stated that the offences for which the FIR has been registered are bailable in nature. However, according to him, the police is harassing him. Since the offences are bailable in nature, I am not inclined to pass any order in the application. As it is expected that the trial court expected that the police would act in accordance with the law by issuing notice under section 41 A of code. As it is available. If it's
Yes.
not available, then we will do.
In both the cases, my lord, same. Grateful, my lord.
Notice issue.
31.
Yes, sir.
I have informed him, as per my lord's direction, I have informed the other side counsel.
Oh, where is it? If he
Rashid,
doesn't have any
PC
mediation,
mode.
I will. Yes.
Rashid, I'm through PC mode, Rashid.
Yes, madam. Tell me.
Rashid, regender, sorry, counter activity is not filed, Rashid. I'm sorry, I requesting this court to grant me 1 week time.
So what counter affidavit? He moved an application and orders 18 rule 17 to examine the, I'll give one chance.
One chance.
Rashid,
With some
I
cost, with some
I-
cost to pay to you.
Rashid, kindly fix it on tomorrow. I physically present this court with the counter affidavit, Rashid.
Hello.
21st. 21st. Young girl, that is all. 21st, huh?
Yeah.
Okay.
Okay.
34.
Please, my lord. 34 for I have filed the modification for today is for orders.
What modification?
Sir, I have filed a security amount 10 lakhs. I want to reduce that amount or are there any problems?
Yes, that's while bail was
Last
granted,
occasion, last occasion already discussed.
bail was granted to you that
Yeah,
time
yes.
yes. Where is that bail order?
Yes, sir. Bail order is page number 9, 10, 11, sir.
कितने number है total?
34. CRLMC 2355. 2009, sir. Order passed.
Bail order 9.
Page 9, sir.
Page 9. Huh? No, 34 gate. 2355.
2355, these are now.
No. Page 9 is something else.
Yes, sir. Or this is the order, sir. I have marked this.
14 number. 14 is K. Badrinath
K.
Pattal.
Badrinath Pattal, sir.
Page 9 is something else, sir.
State of Orissa, State Vigilance, sir. Now it is.
Page 9 is, where is the bail order?
Bail order, sir. Page number 9, sir. My IA.
The IA.
3215.
Okay, number IA page 9.
It's a business case.
Then state, it is always transport to CBI. PML, under PML. Initially it was vigilance.
ED. No.
ED.
Page 9. Which IA you are talking about? Which
Sir.
IA number?
I number 3215, sir.
3215.
15. (2024).
There is no annexure to that IA.
Yes, sir. Next time.
Oh, yes, is there. Not 9. Yes. This condition, huh? Condition number 1.
Condition number 1, sir. I want to change that.
Yes, who is appearing?
ED. We can. No, I have already served the service. They have received that copy.
Let it pass it over.
Pass it over, call him.
Sir,
I'll allow
they
this.
received this.
Call him. Because in his absence, I can't do
In
it.
the cost title is.
No. Change already. Beacon like now he is dealing.
Name is
BK
reflecting the call.
Vivek Naik.
Vivek Naik, yeah, Vivek Naik.
I will pass it over. Let us wait. Let them come.
Okay, enforcement.
43.
43 Millets, would it be your lordship's pleasure to have it tomorrow, Millets? I'm in a personal
Not-
difficulty today.
Personal difficulty. No? Ground of-
Tomorrow, Millets?
Not
Would it be tomorrow?
Some other day.
Next
Yes.
week?
We'll
Tomorrow,
see.
Millets?
How can we adjust? We'll see. Let us see. Okay. Yes.
Millets?
I
Great.
have notice in that matter.
Millets?
I have already issued notice. Your associate counsel says I don't need notice. If you want, I can
Millets,
issue. it.
Millets, I'm seeking some interim relief, Millets. There is,
If anything happens, you move application. I will just simply issue notice. Kar diyo. If any problem is there, then move application. We'll see.
Millard, the old father-in-law, 80 years, 87 years, they have no involvement in this, Millets. Only that, and they have been.
1 minute. 1 minute. 1 minute. Who is father-in-law? 80 years. Let us see. Which matter?
ପ୍ରଥମ କେସଟା 1426 ରେ
87.
87 and 80 years, father-in-law, mother-in-law, they are all based out of Hyderabad.
And
They're all based out of
what are you
Hyderabad.
seeking in the first matter? What are you seeking?
Millets, let there be some no coercive order, Millets. Some protection, Millets. If
What are you seeking in this matter? First one.
Millets, I am seeking quashing, Millets. Quashing of the
Quashing
DV
of-
proceeding.
Washing up?
Quashing of DV proceedings, Millets.
DV proceeding.
Yes,
In the
Millets.
first- In the first matter, the petitioners are granted notice. Petitioners are granted liberty to move application through council seeking adjournment before the court below. And if such application is moved, the same shall be favorably considered in view of the keeping in view the age of the petitioner. Age of the petitioner. First item. Yes. Okay.
Millets, next, third item is the brother-in-law and sister-in-law. They
Okay,
have
sir.
in the DV
Father-in-law,
case.
brother-in-law, I have done it. Rest we will see. Issue notice. Yes.
Very
Rest two
good.
minutes.
Yeah.
Yes.
47.
Millets, any next statements?
He'll give it. Yes.
Grateful.
47, may I please your lordship, I am appearing with the informant in both the sub items, and I am filing affidavit mentioning that considering the age, my lord.
Sorry?
His associate is there.
You say considering the age.
Yes, my
you
lord.
don't-
Yes, my lord. I have absolutely no.
323.
objection if any. And I have also supplied the copy to the state council and the petitioner council.
The party number 2, fire number so and so came to.
Paragraph number 4 and 5, my lord.
Petitioner, education is so and so. Petitioner is the mother-in-law.
Yes, your lordship.
Petitioner
First
is
case, mother-in-law.
Of opposite party. Opposite party. Notice was issued to the opposite party. Persons to the same, who had entered appearance?
Your lordship.
You have entered appearance, file the Wakalatnama?
Yes, my lord. My name is Siddharth Naman.
Entered appearance. The opposite party number 2 has filed an affidavit before this court dated 16/4/2025. Entry we are checking agenda. One to maybe 5. Same to
Same, madam.
For the petitioner appearing for the opposite party number 2 submits that owing to the name submits that giving in view the old age of the petitioner. She doesn't want to press the case against him and extending consent for watching of the FIR and consequential proceeding initiated by her against the petitioner, against the petitioner. However, how many accused are there? Husband.
Husband is also.
However, husband she will pursue.
Husband continue.
However, the opposite party he will continue the proceeding. The same thing, secondary court. If you have same, the FIR number from to quam is yes. Same order in second order, yes. Both the matter disposed of, yes.
49.
Yes. Yes, 49.
49, one Passover, my lord. One
Why-
Passover.
Why it was urgent for today? वकालतनामा was urgent. File the वकालतनामा. वकालतनामा कल order pass ही नहीं. क्यों करते हैं इतना? It was सीधे ही वकालतनामा. Don't so entered appearance and the वकालतनामा.
My lord, may
सब item last item to release it. My land to कोई दो हाँ. Yes.
One point added, my lord. Petition number in the case CRLMC 318, my lord. Petition number 2 and 3 not in charge sheet. Well, সেটা গোটাই
2 and 3.
Petition number 2 and 3
What happened?
not in charge sheet. Not charge sheet.
Not charge sheet. 2 and 3.
2 and 3. Petition number 2 and 3.
So why have you filed for quashing? Huh? But charge sheet has been filed. You will start reading the file after so many hearings. You tell me charge sheet has been filed against you.
Yes, my lord.
Then
I am placing in petition number 2 and 3.
2 and 3, what happened? You have filed the petition for quashing.
Petition number 2 and 3, they have not been charged.
Then why has he filed the petition for quashing?
They filed for quashing for FIR. This case is pending matter.
Is it so? While this case was pending, charge sheet was filed, exonerating you. He has no clue. That's the whole difficulty.
No, I prefer one Passover, my lord.
What
on behalf of Mr. Amitabh
What do you
Tripathi,
say?
one Passover only.
I am appealing for opposite party. And in this case, as the compromise has already been done based on the compromise, and we do not have any objections to
That I have already dictated the order. I passed it over for today because you had no wakalatnama. Now you have given the wakalatnama at the end of the story, and he says something else now. Without preparation, without anything. Whatever you want to tell later on. Yes. Yes. When the do you have any idea when the charge is prepared?
they're not solved problem.
What I'll do is I'll dismiss all the matters and you file fresh petition and do whatever. I'll dismiss all the matters. Yes.
I pray for
All the
one
three matters.
Passover. One Passover, Mr. Tripathi.
Bring him. Otherwise, I'll dismiss all the matters, allow you to file a fresh petition. Whatever you want to tell in that petition, tell. With the liberty. Okay. Pass over dito.
may I please, my lord.
Yes.
Yes, you can that property surety in place of
34.
34.
Oh, yes, right. 34. The hard copy. Petition has approves this court. I file the petition in 3 days and seeking the following release. You are seeking quashing up the entire proceeding.
No, sir. No.
Asking something else, praying something else.
Yes.
Why are you having this kind of petition? I don't understand. How can it be quashed now? Dated 9/9/2009. When he was directed to furnish
the cash security of 10 lakh. And pursuant to the order dated 9/9/2009 passed in CRMC number 2355 of 2009. He has already furnished the cash security, and was entitled to pay. Since then, he has been diligently appearing to the court. At this stage, in the present proceeding, in oral prayer for a release of personal need. The further submits that this is he has been diligently appearing for the conditions were imposed by the court below. Conditions were imposed while granting bail a onerous a notice was issued to the state on 9/12/2024. The council appeal for the which is 9 and council appeal for the state submits that the conditions were imposed by this court while granting bail may be altered by alter and the petitioner directed to furnish property security. Regarding the net to the submission by the parties, regard the condition imposed by this court by the order dated 9/9/2009 furnishing cash security altered and the petitioner is directed to furnish property security of the Sir, my one request. Property should I can spare, sir, my agriculture because my residential buildings they've already attached.
Property. You furnish property with this modification. The present the rest of the order dated 9/9/2009 and been amended for which the information observation and direction you could
Obliged.
Your prayer is something else, you are asking something else.
Name.
Name.
51.
My 51, my lord, I need little time, my lord, because due to communication gap, my lord, I have not been able to receive the instructions, my lord, which I wanted to. I need little time, my lord.
Yes.
This is actually I passing of an affair actually I have gone.
You are appearing for opposite party number
I'm
2.
appearing for the informant opposite party number 2.
Okay.
In fact, the engaging counsel has some difficulty in family. He's not here. He has not been able to brief me properly. That is the whole difficulty.
What are the offenses?
The allegation against me that I have stolen from the same house which is in my possession.
That I will demonstrate from record. Only because of want of proper instruction, I am not able to assist properly. Your lordship will kindly bear with me, ma'am.
Senior counsel appearing for the opposite party number 2, lease the matter and so on. So the interim order shall continue till lecture. Yes, sir.
Some date, ma'am.
Fix a date.
53.
You will go in the first week. Let it be on 5th or 6th May.
5th or 6th May.
You tell me.
Because that
When do you want?
the morning 5th or 6th month will we do?
6th?
Tuesday.
Okay. 6th. Interim order to continue. Yes.
53.
Obligation. Interim order to continue.
Interim
Then
order. Interim order.
I am for the opposite party.
I am for the petition.
Yes.
Here, my lords, the petitioner, who is the divorced husband, has assailed an order of the learned additional sessions judge Gunpur at annexure 8 to the
Annexure
8, page 65. Now, your lordship may see page 66, my lords.
Yes.
Paragraph 2, the court has quoted the brief facts.
Hmm.
And at page 3, the court says that after 3 years of passing of
2000 per month.
after 3 years of passing of such order, OPs filed a petition under 127 CRPC with prayer to enhance maintenance from 4,000 to 15,000 per month, which was registered by miscase such and such. After hearing both parties, court below by order dated 30/11/2018 allowed the petition under 127 in part, directing the petitioner to pay a sum of ₹6 lakhs to the wife and 4,000 to the minor son, enhancing the maintenance amount. Paragraph 3, the court says that the main grounds taken by the petitioner are as follows.
So now the amount is 6,000
Your Lordship may see
per month.
what he writes.
4,000 per month opposite party.
Your Lordship may see the subclause 3 of para 3. That petitioner had filed CS 67 of 2009, MAT in the Court of Civil Judge Senior Division Raigada against OP number 1 on section 13, Hindu Marriage Act,
Has been dissolved.
decreed on 10/5/2011.
Yes.
And the marriage between petitioner and OP number 1 has been dissolved. Now the court has found, my lords, at paragraph 6, my lords may see at page 69.
Yes.
Now this decree of divorce was a contested divorce, my lords. I have annexed the decree, judgment and decree as annexures 1 and 1 by 1, my lords. But the court, on the impression that it was an ex parte decree, has passed the impugned order. So it has to be remanded back, my lord.
Yes.
He has to decide on that basis. Para 6 he rightly holds.
Is as good as a contested decree.
That decree has nothing to do with the present petition. What the reason is this? Even if there is a decree or no decree, wife filed an application during the pendency of the suit. Wife filed an application under section of 125 for grant of a maintenance. 6,000 has been awarded. 4,000 for the wife, 2,000 for the son. That order was passed in 2014. That is on 21st of February 2014.
Yeah.
And at that rate, my learned friend goes on paying for 4 years. There is no default on that part. When
it is increased to 6,000, 4,000, 10,000.
It has been increased to 10,000.
Yes.
It has been increased to 10,000. Only 4,000 has been increased. And taking into consideration to the fact that the husband is now he is a ASI. At that point of time, he was constable. He was doing 45,000 some odd. Both the courts has taken into consideration to the salary. The distressed wife and his own son. He is not disowning his son. And he is going on paying the first maintenance, 125 maintenance in 2014. There is no resistance that such a decree is there, expiry decree or a contested decree. By that time, the decree was passed. He goes on paying. When it has been enhanced, the scope of 100.
But the decree was passed on 2011. 10/5/2011.
Yes. In 11.
Maintenance order passed on
21/2/2014, my lord. 21st of February 2014.
Yeah.
125 petition allowed. Since then, from the date of application, he goes on paying. At the rate of
enhanced, he has a
it has only enhanced. What is the scope? At best, my learned friend may say the enhancement is bad for this reason. The scope of 127 is under challenge before lordship.
My
You are not
is
agreed by this enhancement.
No, I have not
You don't-
agreed. I have not receiving that.
You don't need further enhancement.
No,
You are satisfied with it.
I am satisfied with that. That has been stated by this honorable court.
Yes.
My respectful submission is this, my lords. The revision wherein I had assailed the enhanced maintenance, my lords, that has been disposed of on the basis that it's a ex parte decree of divorce has been granted.
But that is neither here nor there.
No,
How does
what my learned friend says that I have been promoted and I have earned, my salary has increased. To that effect, what is there? What document is there?
Both the courts will have
No, neither of the courts below without any documents.
Yes,
They have accepted it.
Yes, I am taking your lordship. to page 70.
Okay, then I give a direction, you file affidavit.
Yes, let
Neha-
him file a-
Rajesh Neha, I'll see
Yes.
whether this is correct or.
Yes, yes.
In the Rajesh Neha. The petitioner is directed to file an affidavit before this court in accordance with the law laid down by the Honorable Supreme Court in Rajesh versus Neha.
Both parties will file.
Both the parties file.
Till then.
You file, I'll decide it.
Right, my lord. At least he has a grievance for the enhanced compensation maintenance. Let the amount which was fixed 6,000, at least that amount he has no grievance.
The earlier amount you have been
Earlier
paying.
amount is being paid.
No, it is not paid.
You have to keep on paying.
It is not paid since August
Yes,
Your lordship
2023.
may look at my debt
From
tag.
August 2023.
No,
it has not been
I'll
paid.
clarify that.
Yes.
Till then, the petitioner is directed to keep on paying.
My lords, on 18/5/2023, my salary was attached.
It has
Anyway,
not.
you keep on paying the
Let
maintenance
him
amount-
say from
maintenance
which
amount
month it is
as
not-
awarded earlier.
Earlier,
Dated
21 February 2014, and it has not been paid
passed
from
by passed
by the ATJM Gurpur.
Yes. And you file affidavit. both.
From which
I'll
date?
take it.
Let him say from
He
which
is not
date.
paying
Keep on,
since
you
August
continue paying,
2023.
continue paying as per the earlier order.
Your lordship may indicate that if it has not been paid, it will be paid.
If not paid, if not paid.
Since,
And
my lord, it is not paid since August 2020.
If not paid, actually, you
Okay.
take it. You file affidavit, I'll decide it here.
Interim orders to continue.
My lord.
As simple as that, yes.
What date may be?
Yes.
Here, your lordship may kindly turn to. Your lordship may kindly turn to annexure 2, page 16.
Page 16.
Yes, ma'am.
Yes.
A complaint case was filed by the husband, Sunil Kumar Sethi.
Who are you?
I am the accused, Tata Project. My lord may kindly see the pleadings at paragraph 8 at page 17.
Yes.
The government of Odisha have made advertisement for the works regarding carvation of drain in different parts of city of Bhubaneswar, basing upon such advent, complainant's wife being the contractor and doing the business of this work, put the tender before the accused person. So who should have filed the complaint? The person who has taken the tender. The husband files the complaint. The tender, your lordship will see at page 26, it is, work order is with Sandhya Rani Sethi, page.
Power of attorney has been given.
No, nothing. It is not his pleading, my lord. It is not his pleading. Your lordship may kindly see. Complainant, Sunil Kumar Sethi, son of such and such, such and such, such and such. No mention of power of attorney. Then who is the witness? Next page, page 17 is Sandhya Rani Sethi. Who is the contractor?
Who is the petitioner?
Petitioner is Tata Project. My lord, I am accused, arrayed as accused as opposite party, number 4. Assistant General Manager.
Rajendra Kumar.
My lord, page 16. It is admittedly a government contract. I took the contract. He made government as a party.
Tata Project. And who is 3, 4, 5?
My lord, 3, 4, 5 are government officers? Are all government officers?
No, are they accused?
Yes. Page 16, your lordship may kindly see.
But you only Tata.
Tata is coming up before your lordship. Government gave the contract to Tata. Tata gave it subcontract to the wife of the complainant. The wife of the complainant doesn't file a complaint case. The husband files the complaint case, and his specific pleading is that page 18. Complainant's wife being the contractor.
Yes.
Your Lordship may record my objection.
Right. There is nothing, you can't defend it.
I can't improve it here.
Petitioner is implicated, is one of the accused in 160 case number 29 of 2023, besides three other initiated by the opposite party number 2. The allegation against allegation against the petitioner is shown. Yeah, I have perused the complaint. The para 5 of the complaint. Para 5 page 70. Similarly, in para 8, 8 is the following government secretary. 8, para 8, small one. All right. It appears from the allegation that the petitioner wife was engaged as a contractor, and due to the failure in payment of the payment towards the work which has been done by the wife of the petitioner, the dispute arose. However, instead of the wife of the opposite party number 2, the opposite party number 2 has filed the opposite party number 2 has instead of the opposite party number 2 has filed the complaint on behalf of his wife without there being any authorization or power of the perusal of the complaint also reveals that the opposite party number 2 has filed affidavit in support of the complaint, as if he has personal knowledge regarding the transaction. Apart from that, there is no other document which is placed on record to show that Mr. Mishra appeals for the complaint in opposite party number 2 submits that at this stage the court should not be in that because the disputed question of fact could only be traced out during the trial. Mr. Bose, learned counsel for the petitioner, are you relying upon any judgment?
No, I am relying on factual.
Bose, relying upon the admitted factual position in the present case permits that subjecting the petitioner to the results of the complaint is destined to be reality, because the complainant doesn't have the low cost and high vintage complaint itself. I have perused the copy of the complaint, related document of police on the court. I have no hesitation to arrive at a conclusion that the complaint filed by the opposite party number 2, urging the grievance of his wife against the present petitioner, and is indeed not maintainable. And so the complaint fails. Accordingly, once see case number so and so, present question is passed. Yes.
Grateful, madam.
What happened? What is happening here?
Dispensing with
He says that charge sheet has been filed. That is your problem. You are training like that. If you obviously you have to tell him properly. He says that charge sheet has been filed.
Dispensing.
Order of party. Take those short. Yes. 14 minutes.
55.
May I please, your lordship? This is a matter, my lord, your lordship may kindly remember that the husband has come for quashing and mediation was failed. However, because of lordship's, my lord's direction, kind constitution, that the process of discussion was going on. Last occasion, lordship to please to direct the amount which, because my lord, the petitioner is a librarian in the Cancer Institute. And my offer was up to 70 lakhs. My lord was told 20 lakhs. Other day, Mr. Senior Pujari was appearing. Mr. Pujari was appearing on that day.
What do you say?
Yes, he's also there. Now I. So, my lord, my submission before landlord, since my lord was proposed 20 lakhs, and I also convinced them for 20 lakhs. So, because my lord,
I don't remember 20 lakhs.
Oh, yes. I'm just coming. Here,
What is their demand?
As per in the mediation center, there is a talk of 30 lakhs.
30 lakhs.
My lord. That was denied on the same day. For that reason, mediation failed.
You are demanding 30.
My lord. His father,
Anyway, there is a talk,
30,
but
30
failed.
was your demand. Yes.
30 was failed. Then when matter came up for hearing, my lord again put the question how the mediation failed. So my lord, this proposal was 15 lakhs. And they were talk of 30 lakhs. However, then my lord asked to take instruction how much we can pay because there are multiple litigations.
What are you doing?
I'm a librarian in my lord Cancer Harrier Institute, Acharya Harrier Cancer Institute, getting my lord 34,000 salary. My father is staying at Jaipur, Koraput, settled there as retired teacher. And the marriage was solemnized in the 2020-21. Only they stayed 2 months. But as a whole, my lord, I come for a proposal of 20 lakhs.
Peace is very costly.
Peace is cost.
So
Exactly. Your lordship.
Pay a little more and buy peace.
No, I bow down to lordship's proposition. That's why I have convinced them. And also, I'm ready to say
20 you are agreeing.
I'm 20.
20 agree. He's saying 30. In between something you do and finish it up.
as per your lordship. I am
ready.
30, it is better to. So 30 at least he should at least come for a Bible so that it can work out. Because the girl is also, she is also ours. And at best,
What is the age of this girl? She is
24. 24.
22, 24.
And as you lordship knows, if case is continuing family court ended with only a mere 5 lakhs.
But see, I'll tell you, the girl just see the trauma of this girl.
Then one proposal and fairly I'll submit, if lordship kindly consider.
Yes.
If I assistant. At best, I can give you 22 lakhs because my lord was other day was asking for the 22 lakhs last and for.
Okay, I passed the order, 25 lakhs. Okay.
No, like 22 lakhs. 22 lakhs.
For 20,
22 lakhs.
25.
22. No, like 22. He was.
What negotiation? She
No,
22-year-old, she 22-year-old girl. And her life is spoiled. And you want.
Well, 20, otherwise, it will not work out.
If you
I
can
cannot pay.
pay 22, you can pay, but
No,
25 you can't
no,
pay.
because 22, I was telling, 22 will be good enough. If not 25, it will not happen. Again, it will go.
Matter of another 3 lakhs.
No, that will not. Because I cannot go.
You seek instruction.
No.
Come tomorrow. 22. I'll dispose it.
No.
22.
22 is. Yes, he will get the good amount. Yes, it's good done. 3 cases.
Agreeable.
Yes.
In between 20, 25, I will 22 is the best.
Okay.
Yes.
Good.
Shall I record or you will ask your senior? Shall I record your statement and finish it up?
Yes.
Draft the joint affidavit and give it.
Joint
affidavit give it tomorrow.
You lordship record today.
Tomorrow, 22.
22?
Agreeable?
Tomorrow.
Joint affidavit first.
Tomorrow might not be possible because he is pursuing his study. Next week,
Next week, 20. You just do one thing. You file a lawyer petition because it's agreed. So you also record.
That tomorrow she will say that I have not given consent. Don't do that.
So you also record the proposed lawyer's statement.
No, 22.
Yes, you also record today's. Yes.
Council's opinion for the parties that jointly completed that the parties that agreed for the settlement for final settlement towards the health. The petitioner has agreed to pay 22 lakhs as a permanent ability to the party member to Monday, all the.
And at the Milord, the entire payment will be made at the family court because 13B will be filed. Your Lordship may.
You draft a settlement deed and give. Okay.
Oblige, Milord.
Monday, all the matters. Yes. No, sir, 57. 57 the parties conjointly.
57, Milord, in the first one, Mr. Parija
Yes,
was
yes,
appearing.
right.
That matter, mediation.
Councils appearing for parties conjointly submits.
The husband too.
There is a scope of settlement in the scope of out of court settlement between present matter. Hence, the matter is referred to the High Court Mediation Center for exploring the possibility of settlement. The parties are residing in.
Milord, the case interesting. The wife, Milord, the mother-in-law has come for quashing. Husband is staying. Husband is not before Lordship. So husband may be directed to appear to because he is Google CEO at America,
Right.
USA.
The coordinator of the center is directed to issue notice to the all stakeholders. All stakeholders,
Including husband.
The husband of opposite party and by fixing it and explore the possibility by the report. And it is open for the parties to participate in the mediation process through video conferencing mode as well.
Well, I'm obliged that Lordship persuasion, the last matter was compromised.
This is always better.
Yes, that's better.
Matter of
And that was your Lordship referred to mediation. Mediation failed. Now this has now ended with by your Lordship. That is it.
That is the best way of.
Yes. And now 3,344 litigations are continued throughout.
So everything will cost here.
But obliged.
Interim order.
The interim arrangement.
May I please your lordship. My lord, the petitioner challenging the impugned order under Annex 5 and 6, wherein the
Service.
Arranging out 144 proceeding.
Let us see service.
Yes, sir.
Appear. Hemant Kumar? Name is
Already appeared.
Yes.
my lord. My lord, the petitioner challenging the order dated by the Annex 5 and 6, wherein the executive magistrate, the subdivisional magistrate, exercising his power under Section 144, acted like a civil court and decided possessory right.
Which part of the order?
My lord, kindly see Annex 3 at page Annex page 39.
Yes.
My lord, kindly pursued the inquiry report submitted by the IC Dhusuri, PS by DR number such and such.
Pick
Along
the relevant party.
my lord. After death of point show, the petitioner 2 has been possessing and running the aforesaid sweet stall and his proprietorship and has developed the sweet stall investing his own capital. Further, the son of Intuso are separated from each other by then, as per the amicable family arrangement, it was decided and agreed by both parties to running the sweet stall 2 months as a rotation. But the
What
opposite,
happened thereafter?
but the opposite party, are possibly possessing her.
Last
Having been
posting
satisfied with the report by the ISA Dhusri PS and my lord, my lord, reading the relevant. So far, the prime facie is concerned. The OP number 1 is here been it.
Not to create any disturbance until the disposal of the complaint.
What happened in this case?
1 minute. Yes. What is
My lord, in that order, in the first order, the police reported that the petitioner was running this up. And in the second order,
the final order is
handed over
possession.
possession.
Both of you are restrained from entering.
Restrained.
No, no, no,
The
not-
same order is the second order.
No, no, my Lord kindly, however, the IS is for to obtain an undertaking from both you and not, my Lord kindly see, and justified to rescind the order under section 145 CRPC, 144 within 5 CRPC passed by this court dated 22/11.
The restrainment order.
As
so
such,
much is hereby
hereby
vacated.
directed to
The IS
unlock
is
the
also
switch,
hereby directed to
unlock
unlock
this
this own stuff and hand over the.
and handed over the same to OP number 1.
The further orders and however it is also directed to obtain the instructions of both the parties and not to create any matter. And who was in possession earlier?
Earlier petitioner number 1.
Show me.
My Lord kindly see the order abide annexure 3. My Lord kindly see,
Which part?
my Lord. Not the opposite. My Lord kindly see, ensure are separated from each other and by then as for it
You are
is-
opposite party.
My Lord, I am for the petition.
Before the court below. What is the name? The name is Gorango Ananto Ramakrishna. Then annexure 3.
It reveals from the case record that both the parties belong to one family and running a switch still. The petitioner number 2 has been possessing and running the aforesaid switch stall under his proprietorship and has developed the switch stall, investing his own capital. My Lord, kindly see page 39. When the prohibitory order.
Who is appearing?
There is a case, domestic violence case has been pending. In view of the past or in the domestic violence.
No, that's not the issue.
Here is the old parents lordship. That
You have,
is the lordship, 144 lordship.
see, what is the issue? Issue here is,
The
see,
145.
in annexure 3, he says that opposite parties, number 1 and 2 are forcibly enter inside the premises and they are,
And
they thrown away these people.
Yes, your lordship. But
And a restraint order was passed. In the subsequent order, he says that restore the stall to them. How can it be?
My Lawrence friend, it can be said domestic violence case. What is the domestic effect of the domestic violence
My
case?
Lord,
Lordship? In
the-
domestic violence, there is a
My
not
Lord, there
maintaining
is no
properly
scope
in
for
that
the-
view of the order, lordship.
My
Might have
Lord,
that order is in past.
Where
lordship.
where is the opposite side?
My Lord, under section 144 CRPC, the executive magistrate has no power to decide possessionary right or civil dispute or anything. In the initial.
All the other side I understood.
My Lord.
Non appeals for opposite party number 2. So in the interest, last opportunity is given to opposite party number 2. To appear and contest the matter. These matter 2930. It's made clear that no further adjournment will be necessary. Yes.
59.
With my kind submission, Your Honor. After repeated order, he is not paying the interim maintenance of 10,000 rupees, nor he is paying the petitioner. He is not paying the child's school fees, for which till now, since last 7th of April, her class has been started. But she is not going to school as her books, uniforms are not bought by him. And the first quarter is also not paid, which I have already collected from the court and them.
Maintenance petition is pending before court.
Yes,
Sir, sir, I have already, I have already paid the school fees on 9th April, which consists of the composite fee, transportation and food charges. And on March 28, I have paid 60,000 rupees. On 7th March, I have paid 20,000 rupees. And 6th February, I have paid 40,000 rupees, totaling amount of 1,20,000 to the opposite party. And this month, 9th, I have paid 68,430 towards the up-to-date payment
If you
up to June.
have paid everything, why there is a complaint? You have
Sir,
to pay for the education of your daughter. What is
Sir, I have no issue in respect. I am paying it, sir. I am always paying in time, but she is not leaving the daughter.
I have
to the
requested Mr. Das to assist
and
this case.
in
And he has also had the same
sir-
problem. He was saying that you are not regularly paying.
Sir,
When the
I
matter
have-
is listed, before one day you keep on paying. Why are you
Sir, the due was 10th April, sir. I have paid on 9th. And it is the advance payment, sir. It is for the month of April, May, June. It is the advance payment of this season. Sir, this is the,
last whole year, how much you have paid?
sir, I have paid around 2,40,000, sir. And this year I have to pay around 2,90,000, sir. Sir,
How much you have paid already?
Sir, this is the first quarter.
First quarter.
This is the first
2
quarter.
lakh, how much you have to pay whole the year?
Whole the year, sir, I have to pay 2,90,000 or 8. But sir, whether she will leave the daughter to the school, she is not sending.
The High Court is not here to monitor your
Sir,
day-to-day
actually-
affairs in house.
Sir, there is a
You
kind
deposit
submission.
3 quarter, na?
Yes, sir, 4
1
quarter.
minute.
Sir, I have already paid 1 quarter.
1 minute. 4 quarter.
And
The total amount you tell me just how much?
The total amount he has to pay is 2,73,720. The first
2 lakh?
quarter,
2 lakh?
2,73,720. That includes the school fees. Then for the transportation and dresses, that in total, that total comes
So
to.
how much he has already paid now?
He has paid 68,430.
430 rupees.
For which we have not
Remaining amount.
Remaining is
And within 15 days he deposit with the court.
Exactly.
School.
Sir,
And file the receipt.
yes, sir. There is.
Then thereafter I'll
Sir,
leave.
I have a little submission, sir. Sir, if the daughter can be transferred to the Sai International Residential School, then she can.
That decision
Sir,
you have to take. I can't take decision.
Sir,
Where your child will
Sir,
study. I will take the decision.
no,
Or the
sir.
court
it
will
is-
pass an order.
Sir,
You decide.
sir, there is, okay, sir. I will deposit within 15 days the whole year fees and submit the receipt. Sir, give me, sir, 1 month time, sir, because the amount is much more higher, sir. Because I have to pay in installments and I have.
Let him deposit.
Madam, just 1 minute.
Yes.
He has paid 68,430. It's fine. This is for the first quarter. If he is asking for the time, let him pay 11,765 towards the transportation.
Because
27.
that's- see, it's very difficult for the High Court to, manage their household.
That's a big problem with them. Then he is not.
This court will not entertain. I have tried. I have wasted nothing less than
Enough,
5-6 hours.
enough time I have
on
given
your-
to them.
I called you in the chamber. I made you understand. I requested him to. You people are both of you are lawyers. Do you think that the court is meant for your?
No, sir, no, sir.
Sort out your litigation. You sort it out. I send it to mediation. You fight it out. Fight there.
Sir, actually, sir, I am paying, sir. I am
Do whatever.
paying regularly,
Then
sir.
go and sort it out there in the trial.
Your
I will
Honor,
not.
Your Honor, can I tell one?
I will not entertain this.
Your Honor, he is not paying the school uniform.
Don't repeat. Your lawyer is there.
Yes, sir.
I have requested him. Don't repeat. You remain. The remaining quarter.
3 quarters, sir.
3 quarter you deposit.
And
Calculate and deposit.
books are
Yes, sir.
I'll take it up after 1 month. 2 months.
Sir,
The
1
best thing
month.
will be, let him deposit that amount. We will take up this matter in the next week on 20.
Sir, no, sir, I cannot deposit,
And
sir,
he needs
another 2 lakhs,
15 days.
sir.
15-20 days time.
Sir,
Thereby the problem will be the child cannot go to the school because
He has
Sir,
deposited
already-
first quarter.
but he is not paying, he has not paid for the dresses, for the transportation. That's
sir,
the
it is
problem.
already written, sir. It is the transportation and food charges, it is written.
Books and uniform.
And sir, I have already paid her mother 1,20,000 rupees, 1,20,000 rupees to her in this month.
Composite fee
He
paid.
is
transport
45,000?
fee paid. Food charges.
Yes, sir, up to June, sir. Up to June.
Original to the.
It is already paid.
No, I am giving you the details. That is not, that is the crux. He is playing very nicely.
Sir, I am not playing, I am paying the
1 minute.
payments and the,
Hey, you talk to me,
sir, I am saying to the court, sir.
same thing. Details are there.
For the books, for the info and books is 27. This one.
What about the uniform and all?
Exactly.
Comes
Sir,
to
sir,
11,765.
Sir, uniform. Sir, I am okay with that. I can deposit. But sir, I am interested that she should be transferred to the hostel because last year she was unable to
Why
attend
have
the
you
school.
said that I have paid everything?
Sir, I have paid it, sir. I have paid the fees.
See, there are two components. Why, don't try to be very smart.
No, sir, I am not trying
See,
to be.
two component is, first component is the 68,430.
Yes, sir. Yes, sir.
Is towards the tuition fee,
Transportation
fee and the
food
fee.
charges. Yes, sir.
11,765 is the uniform. Who will pay that?
Sir, I will pay it, sir. But sir,
Then why are you saying that I have paid everything?
sir, I have paid it, no, sir. I have paid the
Have
quarter
you paid
payment.
for uniform also you have paid?
Sir, whether I can go alone and
Have
sir,
you paid for uniform or not? I am asking.
sir, I have not
Tell
paid.
yes or no.
No, sir. But sir,
Why have you
whether,
said yes, I have paid?
sir, I have paid all the fees, sir. I have paid all the composite fees. He was saying that the transportation fee.
Within 10 days deposit 2 lakh rupees. Madam, for the children's education. The opposite party number 2 is directed to deposit the opposite party number 2, the petitioner.
Sir, this month, last
Petitioner.
month, sir, I have paid.
Directed to deposit 2 lakh rupees, upfront 2 lakh rupees before this court towards the expenses, towards the education expenses of the his daughter within 10 days. Thereafter, lease the matter after 15 days. Yes.
Sir, already, sir, last month, sir, I have paid 1,20,000.
Do whatever. You are paying it to your daughter, not to anyone else.
Sir, I am paying.
And you
sir, but sir,
are not trying to be honest.
No, sir, I am very much honest, sir. I have already paid.
Why have you tell lie?
No, sir,
That
I
I
have
paid.
not. I have
Without uniform, your daughter will go to school.
Sir, without uniform, sir, whether I can, sir, whether she is allowing.
You can keep on fighting with your wife, no problem. But the small child has to go to the school
Sir,
education.
sir, I am okay with that.
Next,
Sir,
next slide.
60.
My lord, I am conscious what I have to address your lordship with. The lordship may remember it is those matters, one where your lordship has allowed, so other your lordship has rejected. In fact, my lord, though it is there in the record, I have not been able to assist your lordship properly, my lord. May I take your lordship to page 20? It is
20.
Yes, my lord.
Yeah.
My lord, before that, let me also say that yes, it is true, my lord, that cognizance, it is the date of filing of the PR which is to be reckoned and not the
Service.
My lord,
Service on opposite party. Notice has been issued.
no, my lord, they have all appeared. It is the state.
Stay.
My lord, my lord, it is that matter, Factories Act matter, one your lordship has allowed, the other your lordship has rejected on the ground on stating therein
The
that
same matter.
similar matters, my lord.
Yes.
My lord, my lord, date of taking of cognizance is not to be considered, my lord. No, I am conscious, my lord. Date of making of the complaint, my lord. Your lordship,
In that matter, you appeared.
yes, my lord. In the Anil Sureka matter, also, my lord, coincidentally was appearing, which your lordship had.
But that chart which you have given,
My lord,
on the basis of which I told in the open court that I am allowing,
my
the
lord.
chart was misleading.
No, I'll address, lord. If that be so, my lord may dismiss my case. My lord, I'll just try to assist your lordship.
But why have you said that
ନାଇଁ ମୁଁ ଦେଖେଇ ଦઉં ସେଟା ସେଇଆ ନୁହଁ ମାନେ ମୁଁ ଖାଲି ଦେଖେଇ ଦଉଛି
completely misleading? When I dictated the order, I saw what is it.
ଦିଟା ଲାଇନ ଦେଖେଇ ଦଉଛି ଯଦି if it is so I have no case, my lord. My lord, I will never try to.
Yes.
My lord, may come to page 20. My lord may see this.
Be
this is
clear.
the-
First of all, you tell me 106.
My lord,
How to where from the limitation to be counted?
From-
Date of incident, knowledge of date of
knowledge
incident,
of incident
till
till date of making of complaint. I am conscious, my lord.
conscious.
I-
In the chart, why have you said it is beyond?
Because it is the same date. I will show you, lordship. Why I have said I will show here. I will say that. My lord may see it is the complaint was forwarded to the learned SDGM by this letter at page 20. The
Page?
next page is the complaint. Your lordship saw that.
Page
2021.
Yeah.
My lord may see, say that letter says letter is dated 12/10/2018. My lord may see on the right hand side, it is filed before the learned SDGM on 25/10/2018. My lord may see. Your lordship may see also in the order itself. Your lordship may I take your lordship to page 50.
50.
My lord.
The initial has been made by the learned agent, that is date is putting in 25th. My learned friend is saying that 25th is the date of filing of
Yes,
the proceedings.
I'll, my lord, substantiate. My lord, my submission I'll substantiate, my lord. I am not.
Received PR.
No, my
Received
lord.
PR.
2510 received PR, your lordship may see 4 lines below registered. My lord, it is not only date of taking of cognizance, my lord. On the same date he has taken cognizance, my lord, it is this date. My lord, in the meantime also, I have applied for the certified copy of that filing register. My lord, it is because I have verified myself. It is in fact presented. My lord, I'll just tell your lordship, sometimes the affidavit is done on a particular date, but that's a holiday. I have also done that myself. My lord, on Saturdays for PSUs we are appearing. We do the affidavit on Saturday. The petition is filed on the reopening day or, my lord, on a working day. My lord, merely because he has signed on that day.
When the complaint was presented, you tell me why.
My lord may see 2510 and my lord may see GRCO criminal rule number 9. It is said that it has to the date. I'll read that.
You complete the first complete your submission. Then.
My lord may see page 20. The complaint has been, my submission is, complaint has been made, has been filed in the court on 25/10/2018 because it is an endorsement to that effect by the learned SDJ, and on the order at page 50, your lordship received PR and the next 4 lines below registered. So,
okay, I'll take it that day. It's all right. Then when the incident will take place?
My lord, the incident has taken place on, my lord may see, page 26, 21. My lord, page 21. My lord, the 4th para, 21, 4th para.
Yes.
My lord, the incident happened on received telephonic information from the management on 22/7 at about 5:30 p.m. followed by Form 18 on 23/7. Let me concede for a moment, but it is not 22, it is 23. My lord, if it is 23/7, 2018, and it is
25 October.
25 October, it is beyond 90 days.
Yes.
My lord,
according to you, in this case, at least, in this case, according to you, the same day cognizance is taken.
My lord, and my lord, I will also reserve my ear for your lordship may allow me sometime. I have applied for the certified copy. In the meantime, also, your lordship may not allow my application. Your lordship may call for a report when it was in fact filed.
I'll take it because it's the cognizance order itself says.
My lord,
received PR, sanctioned PR, seizure list, and other connected documents.
My lord,
Assistant Director.
my lord, earlier case that we mu bothei parlin thik my lord. Setar bisaya thila mu bothei I have the file.
In the complaint there was a date.
Se complaint re bi sei mo pahe file ta ach my lord date. Mu bhul kar deichi and I have not been able to assist your lordship. No exactly same.
But where is the complaint?
My lord, the complaint is here. My lord, may see page 24. 24. My lord, that Jindal matter also, that's why I got the file. I verified it myself. What has fallen from your lordship, my lord?
24.
24, your lordship may see page date है 12/10/2018.
12/10/2018.
Kintu, my lord, they have, that is the date they have signed that PR. That is not the date when they have filed it. Your lordship may see filing is on page 20. My lord, a judicial record.
But those documents in that case, there was no document.
My lord, thila. Mu bhul kar deichi, my lord. I have not been able to show that to your lordship. Mo pakare ebe file hochi, my lord. Se aro case tar bhi mo pakare ebe file.
My learned friend is addressing that putting the date by the learned ATC, my lord. That date was made.
That is the presentation, date of presentation.
Yes, my lord.
Date of presentation is 106 says date of presentation.
Yes, my lord.
90 days clearly says 90 days, lordship. But facts remain. The 12/10/2018 is the PR has been.
It has been signed. What he says, it has been signed, but it was not presented.
Yes, my lord.
It might have happened. See,
my lord, charge sheet re say.
Director complainant might have signed. The lawyer will take and file it. He might have filed after 2 days, which is the relevant date. The date when it was presented,
yes,
not the date when the.
My lord, even in 167 2 cases, my lord, the charge sheet is signed on some date. But the date which it is presented before the court is the date to be reckoned.
Next week,
not next week. I'll allow it.
Yes, sir.
Yes. They are hard copy. What's in it? You have now? Wonder level. There you should file a review.
My lord.
If you have.
My lord, the whole day I've been waiting. I am not, my lord, that dismissal and allow, that's a different case, my lord. Because there your lordship has held that it was a misleading statement. That's the reason, my lord, I have
That is, of course, a misleading. You in the.
My lord, if your lordship sees that record now also, I have it now.
But how will I know?
No, that's correct. No, but
I asked you to give a chart. You gave a chart. I saw on that day cognizance is.
नहीं cognizance date टा एटा समान अछि जेते एइतला सेतरे भी सेया अछि सेहिति पेंगा my lord say
Whatever, right? That was the chart. I saw the chart. Date of cognizance is.
my lord मोर ही my lord I am not.
I would have allowed that petition.
My lord सेटा मोर भूल लग.
You shown page.
My lord, I showed page 20.
First you showed page 20.
My lord.
This is the page 20.
Then, my lord, page 21. Date of knowledge.
21, yes. And
then, my lord, page 50.
Cognizance order.
My lord.
Page 50.
50.
Okay. 51. Okay,
my lord, the next matter, I would pray your lordship may call it any other day, because I also want to verify a little, because there is a difference of only one day. My lord, I still want that copy to be there. My lord, may fix a small date.
Second matter, adjourn kar diyo. First matter allowed. Yes. Allowed. De do beta.
Both the matters were to let it come, first matter also let it come next week.
For what, my lord?
So I will accept and whether in that.
I guess key.
Hey, that is in the court. Both the matters let it come next week, lordship. I will ascertain from the officer who is filing the complaint whether on that date, 12 the date is presented, whether the letter is dispatched to the citizen or not. Whether that is on the part of the.
My lord, the judicial
council or
the magistrate writes it and
can the director say that no, it is contrary? I'm sorry.
Still he wants.
No, I'm sorry.
Shall I put it on 23rd?
May I only say, my lord, in that case, may I only say, instead of doing that, my lord, may I suggest your lordship may call for a record from the court.
No, I will not do that.
With the documents, sir.
He can't because the magistrate has signed it.
My lord.
He can't. But since I am adjourning the number 2 matter, let it be both the matters should come up on 23rd.
Yes, sir.
23rd
of this month. Because I have read it.
Again.
At least first matter I can allow.
My lord.
If he wants further time, then we'll see. Both the matters, in the same time, you can also check it up. The second matter also, you can check it up. One day difference. Yes. Put 29.
Compromise between the parties.
17. Compromise.
Yes.
Parties are there.
Parties are there. This was the compromise. Parties are not.
And on behalf of people 2, 3, and 4. Informant, mother and father.
They are there.
Madam.
They are present. The informant.
If you want to direct.
Why should I direct it? You settle the dispute, you have to be here. What are the offences?
326, my lords, post conviction, and your lordships have recorded the judgment of at para 4, wherein the Supreme Court says yes, even post conviction also, if there is a compromise between the parties, then my lords, it is open for the court to settle the dispute. At para 4 of order dated,
yes, I have seen
4-3-30-2025. Lordships have recorded this, the law laid down by the Supreme Court, that your lordships have the powers under 482 to settle the disputes. Admittedly, my lord, the disputes have been settled between the parties, and this was a private dispute between two families, my lords. The person, my client,
on the basis of the judgment, either under Article 142 or 482, either of this.
Well, sir.
Have you seen that proceeding?
Yes. It is pending. My lord. They have gone for the revision and revision order. That was rejected. And the appeal is pending. So my contention is only that, but though the appeal is pending, my lord. My lord. Decided. The conviction order is already passed.
Yes.
Have the put with her.
Yes, my lord. That is exactly what the Supreme Court has said, that even if there is a conviction, and that was also a matter under 326, still then the court exercising powers under 482 can, or section 140, under
Now, in that case, the appeal was pending
yes, well,
before the High Court.
yes, well, the appeal was pending. This is the judgment, my lords, para.
Please for 18.
The judgment is also in your lordship's file.
What is that? Appeal.
My lords, your lordships may kindly, paragraph 3 I am placing before your lordships.
Yeah, read it out.
The
I don't have-
appellants assailed their conviction before the Court of Additional Session Judge Amba. During the pendency of that appeal, the appellants and the complainant reconciled their differences and a compromise ensued between them on 13 December 2006. Learned session.
Their appeal was
session
pending.
judge-
There also appeal was pending.
Yes.
There also appeal was pending. Here appeal is pending before Sessions Court.
My lord. Yes, sir.
Sessions Court. The same situation. Check it up. Bring them. When
That is dangerous.
no 326 conviction.
320.
320. In this case also the case which is cited. In this case also 326 only. Here also 326 conviction appeal pending. At that stage, the parties have settled the dispute. And Supreme Court says that either under 142 or 482 it can be quashed. That's what the judgment is, which I have quoted in my proceedings while issuing notice. But let them come. 23rd. Oh. 22nd. 24th. 24th.
24.
Ah, 24th.
I've already filed my affidavit.
Yes. You are not opposing, no? You are not opposing.
Obliged.
C1.
My lord, in this case, I have challenged the annexure 5, in which the land court below has allowed the 205 petition. Land court below has taken cognizance under section 406 and 420. It was a huge amount of money cheating of 60 lakhs, to which the land court below has taken cognizance. But upon filing of 205 petition, the land court below has allowed without putting any condition of deposit.
Condition of?
Deposit, in which I have made objection, citing the judgment of our coordinating bench. In case of Chintan Joshi.
Show me that order. By
My
which
lord,
you
my
are-
lord, I'm giving.
21/5/2024.
In Chintan Joshi versus Niranjan Behra, order passed by Honorable Justice Sankar Mishra. My lord, kindly have a glance to last
Come
fact.
to the, let us come to the fact first. Let us control of the facts.
My lord, I have made objection that it cannot be, 205 petition cannot be used routinely, in which the Honorable
You are the
Justice.
informant.
I am for the informant, my lord. It is a huge amount of money cheating.
Yes.
And
Which
205.
paragraph?
My lord,
Which paragraph? Judgment.
judgment.
Hmm.
My lord, last page, my lord. Para 15.
Yes,
My lord, fifth line.
yes, I read it.
Fifth line, my lord.
I read it. Yes, he is from Bhubaneswar. Huh?
He is a
This man
resident of
is also
Bhubaneswar
from-
and also has his business in Bhubaneswar.
Yes.
Therefore, attending the court can by no stretch of imagination.
Where the case is going on, Bhubaneswar also. Yes.
My lord.
Notice was issued. Service. Who is appearing?
Yes, may it please your lordship. Lordship, I am from the opposite party.
Yes. What is the problem? Why can't you appear before the court? You are
Yes.
from Bhubaneswar.
Lordship, actually, all of a sudden, my mother-in-law became ill and I had to admit her in the Kalinga hospital. So I returned back from Kotak at 1 p.m. I was there in the court till 1 p.m.
No, you want an adjournment.
That's it. I'll be obliged if it is urgent and any day. On the last occasion also, I was waited till the last.
Yes, no problem. When do you want?
That's it.
When do you want?
And any day, lordship. Within after 2 to 3 days.
Yes.
23rd, my lord.
Mr. Rocco submits that he has personal difficulty. Therefore, he is an improvement in the matter. On 7th. Second May.
Obliged, deeply obliged.
62.
May I please the lordship, my lord. I'm challenging a cognizance order, my lord. That is without taking any sanction, my lord. I am a government officer, my lord, and I am covered by tender by my lord judgment, my lord. I prepared a written note, my lord.
So going to the whether petitioners comes under the covered by the judgment Nutraj Sahu versus State of Odisha. The role played by the petitioner is the crucial to ascertain whether 197 sanction is required or not. Also. What role played by the present petitioner? That is the vital, crucial, and whether sanction is required under 197 CRPC or not. That to be decided. So,
Yes.
my kindly glance at 38 charge sheet also. The present petitioner is working as a district child protection officer also. The one scheme is provided by the government of Odisha, the Biju Sishu Suraksha Yojana, that meet for the orphan child and the parentless orphan and shows the rustic children. But the present petitioner, who is the authority under the law, or the sanctioning authority, has given that benefit to the ineligible person who is not entitled to get the benefit of that scheme also. Now, my respect submission also before the court, whether that is knowingly or unknowingly, that can be decided after admission at the head of the trial also.
He has misused. She has misused his official position by granting some benefit to someone who is not entitled.
But that is in ill intention or in bona fide.
Ill intention only.
Ill intention, that is not uncommon in 197.
It is not in good faith, ill intention. But the fact is, he misused his official capacity.
That is important. 197 says so.
Let me finish.
Let me say, I am the petitioner, my lord. 197 says, my lord, that committed during the official duty.
What he says that you have the act complained of. He doesn't come under the colors of duty.
I am
So
submitting-
therefore 197 is not required.
Yes.
That's what he says. Let us see the allegation.
Yes, my lord.
Show the
FIR, my lord. First FIR. FIR was lodged by social activist, my lord, having no role in this case. I am a child protection officer, my lord. Allegation ke one Sibo Sankar Mishra files application for getting benefit under that Biju Sishu Suraksha Yojana. And I granted his application. For that, he 40,000 transferred to his account.
Yes.
My response.
How do you say that it doesn't come
Yes,
under the
yes.
color of duty?
The informant might be a social activist, your lordship will lodge the complaint, but the person who is getting the 40,000 of that scheme, he is not eligible totally, your lordship, that kind statement was recorded in the page 20 and 21, the one statement of the recorded by during the time of investigation, lordship. This is clearly stated.
Come to page 38.
38, charge sheet, your lordship. Yes, I have.
38, read it.
Yes, lordship. During course of investigation, the spot is that.
No, the first one. That on 8.
Yes, sir.
The
In
10 8.
When 8 p.m. the complaint Gopal Das son of one show. A rating presently rating report alleging that in that Mr. Baladar Dr. President Petitioner, District Child Protection Officer Nagara has misappropriated the government fund under this issues and selecting the fake beneficiary, like Mr. Soprasad Behra, who is getting the benefit, and some show.
The allegation is he has misused his official position and appointed fairly few people, as a result of which the misappropriation has taken place. If that is the allegation, then he has during his official capacity has done something wrong, and sanction is required.
But the president, the informant is a social activist from the.
Why are you going to informant? Talk about the.
There is some.
You are not asked to get the sanction against the informant. Forget about his conduct.
Yes.
Talk about his conduct. Whether has he used his official position or not? That's the question. If he has used the official position.
Official person is meant for to do any as per the act and law, also not in illegal manner to give a favor to someone is not common in the government public duty.
So he has misused his official position.
Yes,
That's the allegation. If the official position is misused, sanction is required. As simple as that.
Yes, lots of that.
Why are you going here and there? It is your case.
And beside those judgments, my lord, 7 days before my lord, one GC Manjunath vs. Sitaram, Honorable Supreme Court held sanction needed in even for acts exceeding authority if there is a reasonable nexus between the official duties, my lord.
So, omission public duty, that is my submission. I am not relying the government judgment for factor.
He pays 39 also.
This is
during investigation, reading. The entire allegation is there.
During investigation, it is ascertained the district child protection officer Noapada has misappropriated the government fund on which is Surakya Yojana by selecting fake beneficiaries. Like Sibo Sankar Mishra, son of Show.
Read it further.
Who is neither orphan nor affected or infected by HIV AIDS and intentionally violating the BSSY
Guidelines. Who will violate the guidelines? The official can only violate the guidelines. Who else? Sanction is required. Sanction. We filed written note.
Yes, sir.
He has already filed written note.
My lord, one more citation I have not printed out.
Where your citation already there?
Recent, very recent, my lord.
I have. It might see my.
Yes, yes. My lord judgment covered everything, my lord.
I have taken care of all. I'd like to say anything.
Lots of disposal by judgment Nurprasa versus State of Odisha.
No, I will dispose it up, but do you like to say anything? Obviously,
I will give my written note.
Written note.
2 pages.
Written note 2 pages.
My lord, item 86, my lord.
That matter is the POXO matter, you are physically adjourned today. The opposite party has already appeared. Taken out tomorrow because 21st is the trial date fixed. I train now because of tomorrow.
Same problem, because see what happened is all the press matter, almost everything I dispose of. Okay. All these matters are after notice matters. It takes time.
It is not happened because of the threat submission, because it is a POXO, your lordship, and last occasion he has not appeared. Today he has appeared. What is that?
Who has appeared? The
the victim.
You are seeking what, by the way?
It is not a case of POXO because he is at the age of. I challenging that it is not a case of POXO, but he is tried for the POXO.
So it can be done after 1 week also. What?
Because the trial is going on.
Trial
Yes.
You are going to be convicted on that day. Are you going to be convicted on that? Say yes or no, according to that decide. Wait for 1 week.
Because,
what will
because
I-
it is
heaven is not
special,
going to fall after 1 week.
because it is special act.
It's all right, but I'll take it.
My lord,
21st.
my lord, item 86, my lord. My lord,
21st.
item 86, my lord.
If you hurriedly dates are given,
will
we are
clash
doing
with-
injustice to all of you. All of you are sitting unnecessarily.
Because of violation.
And you I'll give tomorrow's date and tomorrow nothing will happen.
No,
Why
my lord, item 86.
Please give little time so that we can adjust the date.
My lord, because of trial, because I may permit her to, if I will file the time petition, it will be.
Nothing.
So,
is good.
20 no, otherwise, 21st, may not I pray, 21st.
See, sir, please wait.
Because sir, if date will not fix, he's running behind the trial. What's that?
What will happen? He is accused of a workshop case. One day he'll go and appear in the court. What will happen? Nothing will happen. Wait.
So, my lord, at least 25 hours.
Nonetheless,
86, my lord.
So it's set up for mediation, but unfortunately, the other side never appeared in spite of notice. So your lordship that.
who is appearing for opposition in 77?
Nobody has appeared in spite of notice. Notice was served to the police also. Nobody appeared here, nobody appeared in mediation. So your lordship must fix up a date.
We'll discuss it. Yes.
My lord, item 86, my lord.
One
86.
Senior device, senior device. Mr. Mitra is also.
How possible it would be after
Interim to continue.
My lord, item 86, item 86, my lord. Though I have challenged the discharge petition and the court below has fixed tomorrow for framing of charge, my lord.
What can I do? You even charge is framed, I can discharge.
So, my lord, matter may go infractious, so your lordship may take up it tomorrow, my lord. Tomorrow, my lord. I simply pray for tomorrow, my lord. Let it be had tomorrow.
Possible to adjust.
Item 73,
No interim order in.
of the mother. We, my lord, the woman to the.
I know, I told you,
My lord, that
requested you to
matter,
go.
I pray at least press admission, my lord, very urgent, my lord. Now it, my lord, the.
Because I requested you both to go and see that matter.
Yes, my lord. We both went there and see the reality, my lord. The very, my lord, precarious condition, my lord.
Yeah, this is the
Koई नहीं लाने में।
he will adjust.